We'll go ahead and get started now that we've achieved a quorum. House Bill 897, Representative Collins asked me to go ahead and hold that, and so we will. Next bill we have is House Bill 429. Chairwoman Cooper had this bill last year. It passed out, and it was got caught up in rules and was recommitted. We have that bill on the agenda today, and we'll turn it back over to Representative Cooper.
Thank you, Mr. Chairman. This bill is about temporary protective orders, and it simply allows judges, it does not require them to add pets to the list of things that they can put on the temporary protective order. I think, as some of the committee may remember, under President Bush, I spent 4 years serving on his national 30-member Violence Against Women Commission. It was made up of judges and police officers and so forth, and I learned more about domestic violence than I ever wanted to know. Domestic violence is about control, and the person that is the perpetrator of violence will do anything that they can do to hold control over the partner, and that includes using the children, threatening to harm the children, and threatening to harm the family pet. So we have simply on lines 35 through 40 said, ordering the respondent to refrain from harming any family pet and further direct the care, custody, or control of a family pet. And we defined family, thanks to this committee's work last year, we defined family pet. It means an animal kept for companionship and enjoyment, or a household animal which is owned or possessed by either party, or a minor child residing in the household of either party. And we were very specific, where the committee worked on it, and says it does not include livestock, laboratory animals, working animals, or sport animals which are kept for economic purposes. I'm glad to answer any questions.
Questions for the author, Mr. Franklin?
I can't remember what we did in the committee last year. But if you could go explain a little bit more the exception carved out on 39 and 40, why those animals would not be protected.
Because, well, and you bring up a good point. I guess if I wanted to, I mean, I grew up with a cousin whose husband was a big sportsman, and I guess if she had wanted to really get back at him, she would have gone and done something to his hound dogs. However, just to make sure that the concerns of some of our members is that we were not going overboard with this, the committee felt like that this was a good addition and that we would limit it very specifically to family pets that were in the household.
I appreciate that answer. I am concerned that we are not affording protection to all of these animals, and even other forms of property. If we're dealing with with some type of restraining order, there could be instances where one spouse might be the couch potato, has the flat screen 10-foot television that and watches sports all day long rather than helping out around the house, and I could see damage to that prized possession as well. And this will just wonder the possibility of protecting all forms of property. That might maybe a family heirloom, family rocking chair that's been in the family for generations. I would hate to think of someone damaging that.
Well, Representative Franklin, I think that the normal person looking at this rule would be able to see a distinct difference between a prized television and a living, breathing family pet. And I think that, we cannot protect everything, but certainly a living, breathing animal that is is a significantly emotionally to the children of a family or to the domestic partner that is being threatened is certainly different from an inanimate object. Pardon? Line 30? Oh, okay. Thank you very much. And legal counsel says that we do provide for possessions on line 30, provide for possessions of personal property of the parties. That was already in the law. there are no further questions, I really would appreciate the committee's favorable vote on this, on House Bill 429. Thank you.
Ms. Davis.
At the appropriate time, I'd like to make a motion.
Okay. Thank you. We have a few people signed up to speak on this. Cheryl McAuliffe for the Humane Society, United States. Cheryl? If I could ask you to keep your comments brief, I'd appreciate it. Don't want to suppress any comments, but do want to keep the train moving. Thank you.
Thank you, Chairman Golick and members of the committee. I will be brief because there's some other people here who actually take in victims of pet victims of domestic violence. So I'll just be very brief and say that this is a very common occurrence that happens in the United States, and in fact, we just had an example of this, which is in your packet, in Gwinnett County just a few days ago, and I won't go into details, but the man, from what I understand, was under a temporary restraining order when he returned to the family home and severely hurt the family pet in front of the children. And I think that one thing we don't emphasize enough is that children are affected by this, and this scars them for many, many years, if not a lifetime, and I think that's something we need to take into consideration. And I appreciate this committee hearing me. Thank you.
Yes, ma'am. Thank you, Ms. McAuliffe. Any questions for Ms. McAuliffe? Seeing none, thank you. Oh, yeah, Mr. Franklin.
Thank you for coming and thank you for your work. Wouldn't a child also be traumatized if one of these carve-outs on line 39 or 40, witnessing that, whether it be livestock, maybe a guide dog that's not really a pet but a service animal, wouldn't that be equally as traumatic to a child? Witnessing that?
I think it's equally
horrible thing.
As traumatic for children to see any animal abused, but I also realize the practicality of that section.
So you're okay with cruelty to livestock, laboratory animals, working animals, sports animals?
We're not okay with cruelty to any animal, but we would rather see something done in the area of pets than nothing.
Thank you.
Thank you. Ms. Kirsten Rambo with the Commission on Family Violence.
Good morning, Mr. Chairman and members of the committee. I will also keep my remarks very brief, but I just wanted to thank the bill sponsors for bringing this bill, and I'm the director of the Georgia Commission on Family Violence. We have great interest in protecting victims of domestic violence and their children, and we feel like this bill goes a long way toward doing that. I would echo what the others have said, that we know that pet abuse is a common form of intimidation and control that abusers use, and so we support the bill, and we thank you for bringing it.
Thank you. Questions for Ms. Rambo? Ms. Cooper? Ms. Benfield?
Thanks for being here. Just a quick question. I'm curious if domestic violence shelters allow animals to stay there. I mean, it probably changes from shelter to shelter, but I am curious whether that's an option.
I believe that there are one or two that do. There might be some folks in the room who can speak to that more precisely than I can. I think that there are one or two that do, but the vast majority of the certified domestic violence shelters in the state do not. There is an organization that provides shelter for those pets because most of the shelters do not, and I believe they might be speaking today.
Okay, so I'll wait to hear from them. Thank you.
Thank you, Ms. Rambo.
She does, Mr. Chairman.
Oh, no, okay. Well, all right.
No, right. Thank you very much. That brings up Representative Benefield's comment. because there are so few shelters that will take animals, it's one of the main reasons that mainly women, there are a few men that experience domestic violence, but mainly women, it's one of the main reasons that they stay in the situation and do not leave. They will not, just as they would not leave their children, they will not leave their pets when they think they can be harmed, and so they would rather put themselves in harm's way than leave the family pet to be injured.
Thank you, ma'am.
Absolutely.
Thank you very much.
Thank you.
Appreciate it. Ms. Maya Gupta, and I cannot read the name of the organization. Okay, that's probably why. Okay.
Good morning, Mr. Chairman, members of the committee.
If you could pull the microphone just a little closer to you.
How's that?
That's fine.
Better. All
You
right.
can pull it toward you.
I don't want to cough right into the microphone.
Well, we
That's the
appreciate
only
that,
thing.
but
Pardon me. I'm Maya Gupta, and I'm president of Ahimsa House, which is the only organization in Georgia that is specifically dedicated to helping both the human and animal victims of domestic violence reach safety together. And our organization sprang up out of that need that, as previously mentioned, so few of the domestic violence shelters are able to accommodate victims' pets with them on site. Our founder, Emily Christie, was a survivor of domestic violence, and when she was trying to escape the abuse, she found there was nowhere where she could bring her cat. And her cat had really been like a child to her main emotional support during this experience, and she wound up unfortunately losing her cat in that ordeal. So Emily's vision was there needs to be somewhere where no victim of domestic violence has to choose between personal safety and the safety of a pet. So we do work with the majority of the domestic violence shelters in Georgia to provide emergency shelter and veterinary care for pets while their owners are trying to get out of domestic violence and staying at one of those shelters. So I just want to speak to the fact that this bill would be a great asset to us in our work to help these victims reach safety. For example, we were recently trying to help a victim who had 3 little dogs and had gone to the domestic violence shelter but had to leave them behind in the residence. And while we were working on getting them safe, this victim was so concerned about her dogs and them needing to be let out to relieve themselves and them needing to be fed that she was returning to the residence every day to do that with no knowledge of whether the abuser might be there or not. And including the pets on a protection order and perhaps having law enforcement escort her to the residence to assist in doing this or to assist in retrieving them would have really helped us help her. So that's just one example, and I think there are many others.
questions for Ms. Gupta? Ms. Benfield.
I just want to know how to spell your organization's name and how we can get more information.
Of course. Our organization's name, Ahimsa House, is spelled A-H-I, M for Mary, S for Sam, A, and then the word house. The reason it's a funny name is it means nonviolence in Sanskrit. Our website is www.ahimsahouse.org, just all one word. And you can email us at info@ahimsahouse.org. We also have a 24-hour statewide crisis line open to anyone in Georgia, victims or their representatives, and that's 404-452-6248.
Where are you based out of? Where's your location?
Our office is in Decatur.
Oh, that's maybe my district. Okay.
We're brand new in Decatur. Mm-hmm.
Thank you.
Thanks.
Thank you very much.
Thank you.
Mr. Rob Miller.
Hello. My name is Rob Miller. I represent myself. I am actually going to pick up a foster on Wednesday afternoon that's coming out of a home situation. It's not really a domestic violence situation, but it is, you know, a situation where the dog has been abused or neglected, and we're happy to offer support as much as we can to as many pets as we can, because we care. But my concerns with this particular bill, first of all, to make a special designation of pets, aside from number 8, which would provide for possession of personal property of the parties, should allow the pet to go with the particular, you know, whichever party the pet belonged to. And 1411, Georgia Code 411, 15 and 16 is the Georgia Criminal Code that pertains to animals and cruelty to animals. And in 16b, it actually says that each violation of this article shall constitute a separate offense. So we already have a criminal penalty associated with abusing animals, and so it appears that this particular addition offered by the good representative is since it's not really offering any teeth or anything above any of the other law, it's just a suggestion. So if I may offer a friendly suggestion, the Humane Society of the U.S., which we've heard a few folks speaking from today, recently started its Animals and Religion campaign. They're expecting it to bring in another 12 million people and several hundred million in donations. And the way they're going to do it is they say that if you eat meat, you can offset your guilt by donating money to the Humane Society of the U.S., sort of like a selling of indulgence program. I would offer that perhaps we should suggest to these judges, since this is just a suggestion, that if a spouse is going to abuse their other spouse's pet, perhaps they should consider making a donation to the Humane Society of the U.S. And also, one last thing. There was a recent example of domestic violence against someone's prized SUV with their prized golf clubs. And just saying. So that this stuff can happen all over the place, and I don't see a special designation for family pets.
Thank you for your comments.
Any questions? No.
Thank you.
All right. Thank you.
Ms. Abrams.
I'd like to move to pass HB 429.
And this is LC 293775S. And just for the record, this has gone through no changes since it was recommitted. Right. There's a motion. Is there a second? Second. There's a motion. There's a second. Are there any amendments? Fire away.
I thought that the notice of the meeting mentioned that these were hearings only.
571 is hearing only.
It's only that bill that's the
yes,
hearing
sir.
only. Right,
that's hearing only. That's right. We've got a motion. We've got a second. Are there any amendments? Seeing none, any further discussion? Seeing none, on the gentlelady's motion, all in favor say aye.
Aye.
Opposed?
No.
The ayes have it, and the motion is adopted.
Thank you.
Thank you. We'll go ahead and get into House Bill 571. This will, as the notice said, be a hearing only. This is Speaker Ralston's legislation, and he has asked us to carry on with consideration of that measure that we initially considered last session. And what you have in your folder is LC 294001S. You also have a summary that looks kind of like this. Everybody should have it. This is a summary that was put together for us by the Attorney General's office, and I've said this before and I'll say it again on multiple occasions. The Attorney General's office has been a tremendous resource to the committee and to the chair in the last several months in being a good guide on the issues that the state has had to defend in court that have resulted in certain decisions overturning certain aspects of our sex offender laws, the litigation that we're currently in the middle of, and then on some issues that are potential sources of litigation perhaps for the future. This summary, I think what we usually do is we usually go to the bill and do a section by section. What you'll see as we go on is that it doesn't fit very neatly on a section by section basis. So I think for purposes of our consideration, our discussion and conversation today, we actually work from the summary, obviously go back to legislation itself since that's the more important document. But I think from a discussion standpoint, we'll do better and it'll be much more user-friendly if we go ahead and discuss it from a subject matter standpoint, one issue at a time or one area of a time at a time. Then I think we'll do is as we usually do in big-ticket items such as this, is go on a section-by-section, or in this case, issue-by-issue basis, take questions and have conversation as we complete an area, an issue, and then move on from there. Once we've done that, then we'll go ahead and take testimony. And again, we're not moving to a motion today. I think this draft is, I wouldn't say the culmination, but it certainly goes far in getting us where we need to be in terms of addressing a law that has been overturned, dealing with issues that are currently in litigation that we can fix, if you forgive the term, without losing anything in terms of the underlying tenets of the bill. And then there are one or two areas, pure policy calls that we'll open up for discussion today, having to do specifically with the sex offender registry and more specifically who is on the registry now, what possibilities will exist, what possibilities exist now and will in the future in terms of the ability of certain types of offenders to petition in order to come off the registry. We'll get to a fuller conversation of that when we get to it, but just wanted to give you the heads up. All right. So let's start out with the first section you see on your summary, and that goes to appeals. And that's addressed mostly in Section 1. It makes appeals challenging classifications by SORB, and SORB is the Sex Offender Registry Review Board, discretionary. It makes appeals discretionary from decisions of superior courts on petitions for removal from the registry, residence, and or employment restrictions. Bottom line, if SORB goes ahead and classifies an individual under a certain category, and that could be level 1 offender, level 2 offender, or level 3/sexual predator, there is an appeal process. There would be an appeal process in place for appeals of decisions of SORB, both with regard to their classification of an individual, and then if that's appealed to superior court, excuse me, if an individual, which you'll see later on in the bill, and I'm sorry it's a little disjointed, but if an individual, which is again addressed later on in the bill, were to apply to petition the superior court to come off the registry, it would make the decision of that superior court judge appealable in a discretionary manner to the Court of Appeals, meaning if a superior court judge, again later on in the bill, denied a petition to come off for an individual to come off the registry, the Court of Appeals would have the discretion to go ahead and to hear that appeal of that individual, but it would not be an appeal as a matter of right, and that's the difference: a discretionary appeal or an appeal as a matter of right, which I think is pretty straightforward. Any questions about that? And what I'll do is, let me just do this. I want to introduce Mary Beth Westmoreland and Mr. Joe Drolet, Ms. Mary Beth Westmoreland and Mr. Joe Drolet, the Attorney General's office, who are the folks that I referred to before, who have been extremely helpful and a tremendous resource to the committee. Let me ask them if they would just to come up to the table. I will attempt to go ahead and get through it myself as I do, but there will be situations where I just won't have the answer, and to the extent that you can answer the question without, and this is important, the Attorney General's office is defending the state right now in a lot of this litigation, all of this litigation. They can speak to the decisions that have already come down. They can speak to a certain extent on the litigation that's pending right now. They'll probably be fairly hesitant publicly to talk about that and to speculate on the future. We understand that. We respect that. So to the extent that they can answer a question, they will. To the extent that they cannot, please understand why. But again, I'll try to get through it myself, but inevitably we'll punt where necessary. So with that, any questions from committee members on the area of appeals? And again, the petitioning process that I referred to in that paragraph will be clearer once we get to that section, that provision in the bill. Mr. Levita, sorry.
I'm sorry, it was really a procedural question. It was just that. Do you want us to ask questions by section, wait for you to go through the whole bill, and then go back? How would you like us to proceed?
I think topic by topic would probably be the most
Okay.
efficient thing
Thank
to
you.
do, because, again, you got so many cross-references back and forth that I'd hate to go through the whole bill and then come back to a section that actually is referred to 2 or 3 times in
Okay.
different sections. That's just not user-friendly for members of the committee.
Okay, thank you.
Sure. All right, let's move on to the homeless provisions. There's a case that the Supreme Court decided, known as Santos. And what the Supreme Court held is that the statutory requirement of registering a change of residence was unconstitutionally vague as it applied to homeless sex offenders who possess no street or route address for their residence. So what this provision does mostly, well, actually in sections 2, 4, and 6 is address the Supreme Court holding in Santos. It gets into the definition of address. In lines 70 and 71, it states that if a place of residence is homeless, the person is to comply with the requirements set forth later for what is to be provided upon registration. Then in Section 4, it has those registration requirements. All address registration requirements for homeless individuals. It provides an alternative, so the individual provides the places where he or she sleeps and has an in-person reporting requirement. And then in Section 6, in lines 150 to 151, it gets into the penalty provision, the penalty portion of the sex offender law, which provides for a failure to respond to the sheriff where he or she resides or sleeps within 72 hours prior to his or her birthday. I know the sheriffs have got some logistical concerns. We'll hear from Mr. Norris, the Sheriff's Association, coming up. I know they've got some logistical concerns about reporting requirements, and those are well taken because, as a practical matter in these situations, a homeless person is not necessarily going to know where they're going to be within 72 hours as a practical matter. So we've got some language to massage on that, but I think that's fairly easily done. Any questions about that section? Yes, sir.
On lines 41 through 44, and I apologize for not being better prepared on this. I tried to go through it a little bit. My only concern was that if there are sexual offenses, this particular paragraph deals with says that if it's a misdemeanor, it's not going to be considered a criminal offense against a victim who is a minor. And I couldn't, as I thought of it, think of many offenses that would not fall into child molestation. But I guess my concern is if we have misdemeanors that are of a sexual nature, and we don't require registration for those when they involve a minor, that we may be missing the boat a little bit. And I don't know that there are any specifics, but I guess my question is more, why did we exclude misdemeanor punishments from the list of offenses that would require registration if it involves a minor victim?
If I recall correctly, doesn't that go to when we changed the law a few years ago when we made certain offenses a misdemeanor as opposed to a felony, and therefore changes the requirements? And if you could expand on that,
right, that
we'd all be better off.
The statute was changed.
Let me ask you to pull the mic just a little bit closer, Ms. Westmoreland. Thank you.
This change came in 2006, and this did deal with a lot of the statutory changes dealing with Romeo and Juliet provisions. What happened was the code section got changed so that there's a date in here as well, but I believe this is the date fix. That after a certain date, if you have a misdemeanor, you don't have to register. Before a certain date, you do. This was trying to take care of that particular issue of where you've got a date certain that you committed offense on June 30th, 2001, you have to register for July 1st, 2001. You don't. I'm not sure we realized why that was done the way it was done at the time. This makes it just consistent across the board, so that all misdemeanors are treated the same. There was a case that we had pending that has actually been dismissed, with the court waiting on to see what happens if there's a legislative fix for the issue that was raised in that case.
And Mr. Chairman, may I follow up with
Yeah, please.
just a
Let's
couple?
just have a good
Thank
dialogue
you.
here.
And I guess, Mary Beth, if you don't mind, obviously your office has gone through this, and was it the opinion of the Attorney General's office that these misdemeanors, and I'm not talking specifically about the Janarla Wilson case, but that there was no circumstance under which we would want to have a misdemeanant register if there's a pattern of conduct that suggests this may be somebody who we want to monitor?
We didn't go through it with looking at it from that perspective. We were simply looking at it as there's a discrepancy on a date,
Right.
and we're treating some people one way on one date and another way one day later, and we weren't sure why. That's the only thing we looked at. We didn't look at, are there people that you want as misdemeanants to register? That's a policy question for the General Assembly.
I guess what I would ask then, since we're at a hearing stage only, and I know that you are inundated with tons and tons of work, but if it's possible for your office to give a list of offenses that would be covered by this exception between now and the next time we consider the bill, I would appreciate it.
And I don't think there are going to be that many. You're looking at misdemeanor offenses, which either already are misdemeanors, or if the judge was allowed to sentence as for a misdemeanor, which would require a penalty of 10 years or less.
Right, and I know enticing a child
yes.
is another one of those.
Yes.
And I guess that's one of the areas, but that would not be considered a misdemeanor. They would still be a felony where they were sentenced as a misdemeanor, correct?
I believe, no, this code section, the way it's worded currently, is punished as for a misdemeanor. So if the punishment is misdemeanor punishment, they don't go on the registry. For new offenses starting July 1, 2001, they have not been going on the registry.
And this may expand your list a little bit, but if I could have a list of those crimes, and I assume it's all sexual crimes that are susceptible to that 1710 6.2 or whatever it is. No, I'm seeing a no from Legislative Counsel.
No.
So if you could get me a list.
For example, any crime that has a punishment more than 10 years doesn't fit in this category to begin with, because it cannot be treated as a misdemeanor. It would have to be something, aggravated child molestation, for example, doesn't fit here.
Right, but enticing a child does.
Could, yes.
Right. And in fact, there's a specific statutory provision in there for the Romeo and Juliet exception. Mr. Chairman, again, I've got just one or two more questions in this section, if it's okay.
Sure.
And the risk whenever you come to the Judy Committee is that we'll start looking at the original law.
Let me ask you to hold off for 1 second. I think Ms. Travis has got some perspective on the previous point, and then we'll follow up with your next point.
Really, the only change on lines 41 through 44 is changing that word prosecuted to adjudicated, because that's the correct terminology for juvenile court, and that was the change. The language that shall not be considered a criminal offense against the victim who is a minor is in essence the same thing as saying the stricken language subparagraph A9B. It's just a cleaner way to write it. So you all are not making any changes to current laws. It's just the reference is better captured this way.
I'm just not sure. I don't want to make some changes to current law. That's why I'm asking that question.
That's fine.
And then and this is really a question which may be covered, Ms. Travis. I should have just maybe covered this in our colloquy before we convened. But on line 60, and again on line 64, and again on line 69, I don't see where the word address. I see a description, for example, on paragraph D, beginning on line 58. It talks about on line 60, and if applicable, a description of where the mobile home is located on the property. But I see in line 58 through 61 the requirement for the name and address of the owner of the home, but not necessarily the address where the actual mobile home is located.
Line 52.
Okay, but that's in a. Are these all ands? Is this and?
Yes.
Okay, and that may take care of it. Another question I have, since related on line 69, since that deals with a vessel, and we've talked about hull numbers and things like that, but you're not going to have an address necessarily of a boat, and I wondered whether we've ever considered putting in things like dock or slip numbers so that we'll know the physical location of the boat or the live aboard vessel, whatever it is. Is that in current law? Are they required? Do you actually know the location of the boat if it doesn't have a physical address?
I don't know that that's included specifically in current law. The sheriffs could probably give you a better idea of what information they get and how clear that is.
All right,
They'd better be in a better position.
I'll ask the
to
sheriffs.
correct.
Thank you, Mr. Chairman. I appreciate your indulgence.
Sure. No, well, this is exactly why we're here. Ms. Cooper.
Thank you, Mr. Chairman. I just, back on line 41, and I think Representative Benefield, we were both, what, it says conduct that is punished as a misdemeanor. What kind of conduct? It's been asked for a list, but could you just tell us a couple of things that would be?
And in fact, Mr. Drolet just pointed out enticing a child is not one of them because it's got a 10 to 30-year punishment. So you're talking, I believe, child molestation can be, but these are offenses within the discretion of the judge, and it's going to be something very minor. The judge has the authority to punish as give a 12-month sentence instead of a 1-2 year sentence, or when they're in juvenile court. I don't have examples where that's been done. Again, our only point on this section is to try to be consistent on when that's applying and ensure that it's applying uniformly.
It's all the Romeo and Juliets that you all put in when you pass that.
Yeah.
It includes all of those specifically.
And basically, that's all.
Well, there are some others that could be treated as a misdemeanor, but like child molestation, sodomy.
I don't think child molestation carries more than.
Let's be clear. What is the conviction for in that situation? As you know, there's a conviction for X, and and then there's a punishment.
Right.
Just so it's clear for members of the committee.
The easiest way to think about it is all of the crimes that you all allowed Romeo and Juliet for specifically would be those people, if they got treated under the Romeo and Juliet, would not have to register.
Okay.
And that contemplates the 3-year age difference scenario.
Yeah,
Right.
3 or 4 years, depending
Correct.
on what the
Okay.
offense is.
Okay.
And I stand corrected on the child molestation again because that does have more than a 10-year punishment as well.
Yeah, and then there's a general.
But it's not only within the Romeo and Juliet context, correct?
Right. Then there's generally a code section that says a felony crime can be treated as a misdemeanor
Mm-hmm.
if the sentence or if the punishing range is less than 10 years.
10-year maximum.
That's 17 times 5, Mr. Chairman.
And
Okay.
I'm gonna say, in my experience, it was very, very. I don't know. I never saw it done, but I'm not going to say it can't be done. So a felony, sex offense. I don't know the exact answer.
And that goes to Mr. Levitas' point, I think, from earlier, in that if you've got felony conduct, we'll call it, that's actually punished as a misdemeanor, I think what his concern was, and I think a valid one, is that is perhaps a loosening up in that scenario. I think that's where he was going. He can speak for himself, but he's not here right now. But I think that's where he was going. Not that we have to go ahead and solidify that today, but I think that's just a point for clarification later. That's all. Ms. Cooper, do you have something else? No. Okay. The next section on page 2 of your summary, language consistency, terminology. I really don't have any comment on it. I think that's just all structural terminology. Do the folks in the AG's office have any comment on that, just in terms of what it is and why? I really didn't focus on that personally.
No, there are parts in here that the term actually is a victim who is a minor, a crime against a victim who is a minor, and there are times when it's just not spelled out as completely as it needs to be. The phrase should be the same everywhere.
Okay.
And that's, I believe, most of what those are.
So it's all structural as opposed to substantive changes.
Yes.
Okay. The next section, I'm sorry.
I'm sorry, Mr. Chairman.
No, sorry.
On lines, the section 2 reference on lines 52 and 54 is the ones which remove the reference to temporary residence. I believe there may be some concerns from the sheriffs on that one that you may want to address later.
Okay. All right, the next topic is our misdemeanor offenders. You'll see that under that specific provision of Title 42, misdemeanors and juveniles are exempted from registration, but only if the offense occurred after June 30, 2001. This was subject to a constitutional challenge, and the case was dismissed pending legislative action. The proposed change in lines 40 to 44 changes the law to remove the registration requirement for those convicted before 7/1/2001, so that all offenders are treated the same. So you've got, just to make sure, put a final point out, you've got individuals who are misdemeanants and juveniles who committed a certain offense. They were exempted from registration if that offense occurred after June 30 of 2001. This proposes to take those, take the individuals who committed the same offenses prior to June 30, 2001, and to exempt them from registration requirements.
That's right.
Give us, going back to Mr. Levitas' sexual battery. Is there a laundry list, or is that we're talking about?
It would be a first, would have been at that point.
And these weren't situations where you had a felony treated as a misdemeanor for punishment purposes. These were misdemeanors, which prior to June 30, 2001, had a registration requirement. The law was changed such that that exact same conduct did not require registration after June 30, 2001.
And what the suggestion here is for is to make sure everybody's treated the same.
Okay.
Before July 1st, 2001, or after July 1st, 2001, if it's a misdemeanor, it's either exempted or not exempted.
Okay.
Instead of having that dividing line.
But it was misdemeanor conduct at that time. Okay. Or committed by a juvenile.
Right.
Okay. Questions about that topic on misdemeanor offenders? And just for members of the committee, this isn't a one-time shot in terms of questions. If something comes up later on, we'll go back. It's not a problem. Okay, let's we'll move on to the email. Yep, fire away.
Oh, your paper covered me up. That's why you didn't see
Oh,
me.
sorry.
Just a clarification on misdemeanors that would be covered. Wouldn't there be a couple of others? I'm thinking peeping Tom or indecent exposure. But sexual battery, I guess, would be the one that's considered the most serious. Is that correct? Okay.
That's one we see most often.
That's it.
We'll move on to the email information. We've got a case, White versus Baker, in the Northern District, challenging the requirement to provide email addresses, usernames, and passwords, TRO in place on Internet identifiers. Bottom line, what we propose to do is to remove the password disclosure requirement. We could still have the email address and username requirement. In terms of my concern on that initially was that in terms of enforcement, do we lose anything on the enforcement side by virtue of not being able to get the password, or are we secure in our enforcement abilities by virtue of having the email address and the username?
I think, the point on enforcement is, and I'm assuming the email address was added because you're getting predators sending emails so that you have the same thing. You have a home address, you have a phone number. Well, now I'm going to give you my email address, so we've got this information so we can go, this is somebody who's on the registry. The same for the usernames. The concern, I think, on the passwords is that gives you, I've not only given you your house address, I've given you the key to your house. Essentially, and I think that if the law enforcement needed the passwords to get that information, then that would be something that could be obtained otherwise through other methods, probably.
Do we get into any possibilities of litigation on? Do we have any potential First Amendment issues or any identity fraud potential issues if we stick with the password?
That's the basis for the current litigation.
Oh, okay.
That's what we're litigating
Okay.
on the case right now.
All right.
And the court in Utah already ruled on that on First Amendment grounds and struck down the
Okay.
password provision.
Okay, Mr. Franklin.
Picking up on, is there anything that we lose by not having the password? The prosecutors are still able to read emails in their account without a password, aren't they?
Yeah, what you're seeing is somebody, if you've been sending emails to, for example, a child victim, then you've got the emails, and you can see the email address and tie it back to the registry. If you take out the password, what you take out and this is the concern in the litigation, somebody going in, I've got your email address, your username, and your password. I can go into your account and start sending emails from you. And that's, I think, the concern that's brought up the litigation.
Thank you. Any further questions on the email information topic? Ms. Travis.
There's a cross-reference that's going to have to be added to the bill to take out user passwords from the definition.
Oh, yes.
It's not in here. It's
Oh, okay.
one of the things that you wanted me to mention.
Okay. Okay. Okay, the next topic area has to do with out-of-state offenders. This goes to the Supreme Court case of Sharma. Sharma versus State. Prior to the court's holding, my understanding is that we required, if they were a sex offender in another state, they had to come here and register as sex offenders here. And what the court essentially held was that that would not be allowed unless the offense that was committed out of state met the elements exactly of an offense here that required sex offender registration. Is that correct?
That's correct.
Okay. And so what this proposes to do, is that someone who moves to Georgia from another state and was required under federal, tribal, or military law has to register in Georgia, as well as someone convicted in Georgia of a criminal offense against a victim who is a minor or a dangerous sexual offense, the latter portion is current law. Could you clarify that for us a little bit? That's a little bit confusing on...
It becomes a question of whether or not when someone moves from another state and has to register in the other state, should they register in Georgia?
Right.
And I think the original intent, or at least what we're presuming under that subsection, is that was the intent of that provision. Because it said a non-resident sexual offender, what the Court of Appeals said was you have to look at the Georgia definition of sexual offender, and if it's not identical to the offense that was committed, and in the Sharma case, it was clearly a sex offense, but it wasn't one that we had in our list. They said, therefore, it doesn't fit. So the question is, do you recognize registration of sex offenders from other jurisdictions or not? And by taking out sex offender, you are recognizing the definition from other jurisdictions.
I see. So by virtue of using the word sex offender in our code, all of a sudden you had to meet that definition if it wasn't an exact fit.
That's right.
With the elements of the other state.
That's correct.
Then and that was the nature of the challenge. By virtue of taking out the word sex offender, what that allows us to do is if they have registration requirements in another state, that automatically gets them on the list, or kicks in the requirement to be on the registry here, or has been convicted, of a criminal offense against a victim who is a minor or any dangerous sexual offense.
Right.
Okay. Is that clear to members of the committee? Just want to make sure that we're sort of opening that up in order so we can go ahead and cast that net. That we're changing not the definition, but we're taking the reference out to sexual offender in order to be able to go ahead and cast the net and actually include those people who were sex offenders and on a registration in another state. Mr. Everson.
Thank you. Assuming that all the stars are aligned and this offender committed the offense, and let's just say the state of Pennsylvania, and now he's looking to relocate to Georgia, and all the stars are aligned, does that individual fall under the 72-hour rule as far as reporting when he relocates to Georgia? Or
anybody relocating has to register.
Yes, but I don't see the time frame. Does that individual fall under the 72-hour rule as far as someone here in Georgia being released from prison?
I believe it does.
I believe it does. It's not covered. It's not in this provision, but I believe it is.
Okay. Some of the learned attorneys.
Well, let me ask Ms. Travis to clarify that when she can. I don't know if she can do it right now off the top of her head, but if I understand the question correctly, it's to...
Yes, I've read the summary, and Section 3, line 87 through 92, but it did not define what time frame that person is to report to the local sheriff's office to register as a sex offender.
And the question is that ensconced in existing law to the point where we don't have to worry about it?
You got it, Mr. Chairman.
And the answer to that question is I don't know, but we're going to find out.
That's a good question, because 42-1-12, F is what requires them to register, requires people to register, and it does use that term sexual offender. So there might need to be some tie-in to that to make sure that that's clear. That's where the time frames are all given, and the precursor to it is a sexual offender, and since this person is not a sexual offender, we might need to change that.
Right. They would be required to register, but wouldn't be a sexual offender.
So you don't fit under the time frames under F.
Mr. Norris.
I think it's in line 99.
No, the problem is line 96, where it's any sexual offender required. That's where I'm finding the problem.
Right.
By virtue of the reference to any sexual offender required to register under this code section, that doesn't necessarily capture the out-of-state scenario?
That's what my fear is.
Okay. That can easily be remedied. I mean,
Jill's point, I think, is well taken, that we've taken the word sexual offender out to be sure we capture the people coming from other states who might not fit that technical definition, but this reference in F is to sexual offender.
Right.
So, as it relates to our state laws.
Right.
So we can add a clause in there to include the individuals from out of state.
So it's going to be 72 hours.
Okay.
Thank you.
Thank you. That was a good catch. Mr. Franklin.
Thank you. While it's in the existing code, I just wonder if you could help me a little bit on lines 88 and 89, where it says who's required to register as a sexual offender under federal law. Could you help me find where in the Constitution of the United States federal government is authorized to pass such a law?
I believe I've been here and heard that question before, and I understand your question, and I think the Constitution allows for it.
And I appreciate the answer, but the question was where?
I think the Constitution allows for it, and I'll defer to the wisdom of the committee on the rest of that. Thank you.
Thank you for not answering.
Thank you, Mr. Chairman. My question goes to whether either in existing code or somewhere else in the bill, I know we capture folks from out of state, and I would hope that ICE or whatever our current INS is called would capture these folks, but what about somebody who comes from another country and resides with the United States? You would hope they wouldn't be here, but let's say they somehow are in the country, they have a conviction for what would otherwise be a registrable offense, and let's say it's verbatim what Georgia code provides. Are they required under this bill to register?
If they're convicted in another country, I don't believe we capture that information. I think it's been tribal law, military law, laws of another state, and I don't believe, and Joe, correct me if I'm wrong, but I don't think it captures convictions from other countries, and there may be a lot of practical difficulties with trying to do that, but the current law does not capture that information.
And I'm sorry to press you on it, but can you give me something? I would not want to treat somebody from out of the country better than we treat somebody within the country. So can you give me some idea of what the practical difficulties are in doing that?
I'm not the one who deals with it, but I think from the sheriff's perspective, you're looking at trying to first translate the laws of another country and figuring out how they relate to our laws. You're back to they don't have a registry necessarily. I mean, this works because virtually the states all have registries, and the federal government has a registry. So we've got a way to tie that in. We don't necessarily have that kind of information with
my sense of it is that there's got to be some sort of, I mean, he says with an air of hope, information sharing resource at the federal level with the Department of Justice, so that states can go and interface with that on a, I would hope on a timely basis. You have to wonder how often that's updated. when do they get information of individual X coming into the United States, who has that in their background, if they even know that, and then the ability of the state to interface with that federal information resource and being able to update here as practical.
And it would be covered if one could establish it. In other words, the Section E of 42112 right now has 7 different areas that are required to register. One of them is convicted after 1996 of a criminal offense against a victim who is a minor, which is defined in the Act, or is convicted of a dangerous sexual offense after 2006. So, and those are defined. The problem is recognizing, finding out the information, certainly, from Bulgaria or wherever, that a person has been convicted of something which fits those definitions. The person technically is required to register already.
Here's my concern, and maybe that is a question for Mr. Norris or one of the sheriffs as far as the onus it would put on them. But I guess my concern is that if we legislate a change that says you have to do it if you're from outside of Georgia, one of the territorial states or territories of the U.S., that I as a justice would read that as saying, well, they knew at the time that it was required under this existing code section. By enacting this change, they have intended to exclude from coverage people outside of the United States. And so that's my concern. And again, I don't want a sexual predator, just because they happen to be from outside the United States, to evade the registry if they're now legally or illegally, for that matter, within the United States.
I mean, we could go ahead and just, include it, and then the question, but the greater issue is how do we identify them, and which...
well, maybe that's a change for a later date so that I don't...
No, I mean, we definitely, the point's well taken. I mean, we should definitely include it. I just wonder how we can go ahead and make sure that whether it's local law enforcement or here, even at the state level, can go ahead and get that information in a timely manner. But we can find, if it's there, we'll find out.
Okay.
I mean, the short answer is if we can, we will.
Right.
I just don't know.
Technically, it's covered now.
And I do have another question.
Let me get to Ms. Abrams,
okay,
then we'll shoot back. Ms. Abrams.
I think we've said that we're going to think about this, but I would like to caution us that what constitutes an offense against a minor in other countries may be very different socially than what we would consider an offense against a minor. And so I think as we think through trying to marry our laws or align our laws with international laws, international law and international morality standards are very different. And I think we run a very grave risk of capturing people just automatically that we don't intend to capture. So I do think that is, if we're going to think about that, and I think the representative's point is very well taken, but I would caution us to be very deliberate about how we think about it and how we make sure that our moral standards are aligning with the standards of other nations.
That's a point well taken, because you're going to have extremes from both ends. You're going to have some cultures where certain conduct is considered in a certain light, whereas in others it's not. Of course, that's not a function of culture; it's a function of their laws and how that matches up with ours. I wonder if it's a situation where we're actually, I wouldn't say deferring, but it's a matter of that conduct is that conduct, and how is that conduct recognized here, regardless of how it's recognized there.
Right, and what constitutes conviction? I mean, I think there are a number. The challenge with aligning American law with international law, hence the debacle that is the International Criminal Court, is how differently laws are developed, applied, and adjudicated. And I think that's the challenge we should have. We should take into very cautious consideration as we think through trying to, because I do agree that we don't want someone to come here seeking to escape or evade treatment, but I also think that we need to recognize that we have a very complex legal system that is not replicated in all the other nations that we would grant entry to.
Mr. Levitas.
This goes to lines 202, and the only reason I'm bringing it up is it's in the same area with the registration issue that we just raised. Line 202, and there was one other place in the bill, and I cannot find it now, but let me ask the question. On line 202 and 203, it talks about, this is during the appeals process, it says that the board shall notify the sex offender by first-class mail of its determination of risk assessment classification. And my question is, where does that first-class mail notice go to? If it's a change of address situation, do you mail it to that? Do you mail it to the former address? Do you mail it to both? Could they mail it to me and that would satisfy the code section?
What this is relating to the SORB's classification as a level 1, level 2, or sexually violent predator. Currently just says send a copy. And so this is trying to strengthen that so that the person who's being classified gets a stronger notice. I believe the board is going to have whatever the current residence is at the time they're reviewing it. And that would be my understanding of where they would send it is whatever information they've got is current, that's where they're going to send the notice.
And they'll tell, I'm sorry to interrupt, allow you to continue. My sense is that when the representative of SORB comes up, they'll be able to put a finer point on that. I also understand that to be, I think, a codification of recently promulgated rules that they put out late last year. Is that a correct statement?
And so I guess as they're coming up, if they could just be prepared to, they don't need to wait for a question, but just address that issue. If it's in the rules where they send it, although, again, I think it ought to be in code that it goes to wherever it is that they want to send it, whether it's to the last known address or the current address or both. And that issue comes up on line 202 and again on line 250. It's the same issue. Thank you, Mr. Chairman.
Yes, sir.
Oh, Mr. Chairman, I'm sorry. I do have one other one.
Sure.
Lines 301 to 304, this is also in section 7. It says that in addition to the requirements of the registration for all sexual offenders, a sexually dangerous predator shall report to the sheriff of the county where such predator resides 6 months following his or her birth month and update or verify his or her required registration information. I would suggest that we consider including within before 6. Otherwise, as the law reads, they have to show up on the date 6 months following his or her birth month. So I would suggest that it's within 6 months following his or her birth month.
It's supposed to be a twice-a-year reporting, so it is supposed to be on...
Actually on that date?
Yeah.
And so if they don't show up on that date for whatever reason, they would be in violation of the law.
I don't know how the sheriffs are interpreting it, but the way this is designed is if your birthday is on March 1st, then you have to come in, I think, within a period of March 1st, and then whatever 6 months, what's that, October, September, I don't know.
Okay.
On September 1st, which could be Labor Day, and again, the sheriffs might be able to...
And what if that day happens to fall on a holiday and where'd that ever all? Okay. Okay. Thanks.
We'll just put Mr. Norris on notice on that when he comes up. All right.
Thank you, Mr. Chairman.
I guess what I was trying to say is if you put within, then you're kind of taking out the strictness of the twice-a-year reporting.
Makes sense. Thank you.
All right. The next section goes to removal. We've got a list. Actually, you don't have the list. I think I've got a list here of the current mechanism. Current mechanism for removal from the registry. Right now, and I think I've got the right list here, right now convicted sex offenders may petition the court of the county in which they were convicted for removal from the registry if the court finds that the offender does not pose a substantial risk of future dangerous sexual offense. The sex offender was convicted under various code sections. The sex offender was under age 21 at the time the crime was committed. The offender has no prior sex crimes in Georgia or United States. They didn't use a deadly weapon. The victim did not suffer physical harm or visible bodily injury. They've been leveled SORB has leveled them as a level 1. And 10 years has elapsed since the sex offender is released from prison, probation, or parole. So you've got the sentence. They're level 1. You've got the sentence. You've got the probation. Then you've got 10 years after that, which is the current state of the law. What we have is a possibility of it presents, and this would be a policy change, a potential policy change of some sort regarding removal. And what it would do is specifically in Section 9, lines 365 to 399, it sets up a process for petitioning to be removed from the registration requirements, residency, or employment restrictions. It sets up a process for filing the petition in the Superior Court where the individual was convicted, or where the person's residing if the conviction was out of state. It provides for the sheriff to defend as the entity who would keep track of the offender, and provides for a copy of any such order to be sent to the GBI. And again, the appeal, this goes back to Section 1, the appeal from such a provision would be discretionary to the Court of Appeals, again, as set out in Section 1, lines 26 to 27. What you've got now, I mean, and this has been a topic of conversation I think a lot of us have had on both sides of the aisle. What you've got now is a situation where you've got your level 1 offender, one-time offender, which is not to minimize the offense itself, but you've got a one-time offender spending right now the rest of their life on the registry, being treated the same way as a level 3 predator. The way I look at it is I do a little analogy to theft crime, and you've got theft by taking, if I'm not mistaken, at $500 or more is a felony. On this side of the felony theft range, and then you've got your armed robbery over here, one of the 7 deadly sins, if I recall correctly. Two very different crimes, and as a result, generally two different punishments as a practical matter going forward. What you have now in terms of who's on the registry and for how long, my understanding is that, not having been on the committee, although having voted on this in the last several years like most of us in this room, we have a situation where you've got what is potentially a significantly less of a threat to society being treated the exact same way as a level 3 offender, a sexual predator. What this proposes to do, and it's not, the bill itself is not complete yet because we have to determine, and that's not really determined here, as to what the threshold requirements are or would be for this individual to be able to petition the Superior Court, the sentencing court, to come off the registry. We have yet to really identify the threshold definition of that individual yet. But what it would do from an operational standpoint is provide for this particular type of person, this type of offender, again, we haven't really defined it yet, to be able to petition the Superior Court. It's not a get off the registry list free card. I'm going to say that once, and I'll probably say it 100 times, just to make sure that there's no misunderstanding by anyone. It would allow for the petitioning of the Superior Court, the sentencing court, to come off the list. And of course, the Superior Court can grant that. The Superior Court can deny it. The Superior Court can say, not sure, come back in a year, come back in 2 years, come back in 3 years, whatever it is. It would place that discretion in the hands of a judge to make that determination. It would not be a determination made by the General Assembly. I don't think we're in a position to do that. I think the people who are in the best position to do that, frankly, are our Superior Court judges. That's why we have them. That's why we pay them to make decisions just like that. We would have a situation, I believe, in determining the threshold definition of who even gets to petition. I think we would want to have a situation where it would be an individual who has been determined to be a level 1 risk. And speaking only for myself, only an individual who has been determined to be a level 1 risk by the Sex Offender Review Board, does not pose a threat to society, and so forth. I think there are many different definitions. I mean, there are a lot of ways to go ahead and try to characterize it. I characterize it mostly as the individual who made a mistake, a serious mistake, and got a serious punishment because of it, and rightly so. But then the determination has to be made, okay, a crime was committed, a punishment was meted out, it was served. Now the question is, does this person pose a risk to our society going forward? And even more to the point, do they go ahead and represent a risk such that they should be on the registry for the rest of their lives? as opposed to a level 3 predator, who I think we would all agree is absolutely not the kind of individual we want to have any flexibility with. But the issue right now is the fact that from a registry standpoint, where the law treats effectively the level 1 risk and the level 3 risk the same. And the question is, what, from a policy standpoint, what, if anything, are we going to do to address that potential imbalance in how we treat that situation? If you look at the applicable lines in the bills, 365, 369, in Section 9. Again, you've got the court releasing from the registration requirements. The person has been classified as level 1. They were sentenced to a crime that became punishable as for a misdemeanor on or after July 1, 2006. In other words, the offense that they may have committed may have been a felony then, but the General Assembly, in its wisdom, made it a misdemeanor if it were committed after July 1 of 2006. Or you have a situation of the hospice facility, basically the individual who's permanently disabled, incapacitated, and obviously is a pure non-threat to society because of their health. The sub-issue on that I've been discussing with the AG's office is, and you look at line 369, has been classified by the board as a level 1 risk assessment classification. What we have to do really is to determine who has the ability. Now, they may have been leveled as a level 1, but the question is, we have to go ahead and define who it is that we think as a policy matter warrants the ability and the opportunity. It's not, again, it's not the ability to get off the registry, but just the opportunity to petition. Who is that offender? If anyone, and that's a policy call for the committee to make and the General Assembly to make. At the very least, it is someone who's a level 1 risk. What I think we have to do is, I think we do better by the law to identify and define exactly who we're talking about, because a level 1 risk assessment, it doesn't get into the crimes that those particular individuals committed, correct? And the question is, do we want to go ahead and define those? Well, my sense is that we should, so that there's a very clear line of demarcation as to who can petition and who can't petition, and I think that'll be fairly clear. I try to be as clear as I can on that. Maybe I was, maybe I wasn't. Ms. Abrams?
At the appropriate time, I did have a question about Section 9.
Sure.
And with your permission, would like to ask Sarah Tonchi to come help me walk through the challenge.
Sure.
And I'm going to pass around some proposed language. I think Sarah, you got to go over there. Yeah. Pass that around.
No problem.
The proposed language that I'm passing around would actually go to speak to what Representative Golick, Chairman Golick was mentioning. I think there remains a hole in the level 1 classification that I think was unintentional, and the challenge is that in order to receive a level, you have to be there are certain parameters. So if you were convicted prior to this time, if you were convicted prior to this time, but are not currently incarcerated, the board has no ability to level you. You're not under their jurisdiction, and there's no process that allows them to go back in and ask for leveling. And so if Sarah can walk through this, what this would do is actually provide a very narrow set of exemptions to allow a certain group to be considered because they committed offense that we would consider level 1, but are not currently within the jurisdiction necessary to let them actually get that level 1 classification. And having mangled that, I'm going to let Sarah explain it more clearly.
Okay. Thank you very much, Representative Abrams. What we have here is a situation where most people on the sex offender registry have not been assigned a level by the sex offender review board. So, and while what is outlined in Section 9 goes a great way towards the progress we want to see made, there's one little piece that we believe might have been left out, and that would apply to the people who were convicted before July 1st, 2006, and who are not currently in prison because they will not receive a level designation by the Sex Offender Review Board. And just an example of this, I know y'all like to kind of know what situations you're looking at. One of our clients is a woman who is a mother, and she allowed her 15-year-old daughter's 17-year-old boyfriend spend the night at their house. And her conviction is for being a party to the crime of statutory rape. That is literally all that was involved in her conviction. And she's not somebody that deserves to be on the registry. And in fact, and as the way the law is written, or the way the bill is written right now, she wouldn't be allowed to apply for removal or for consideration for removal, as the chairman has clarified a number of times. So we have an amendment here. Although I have discussed with the Attorney General's office, there's a couple ways we could go about doing this. But this is a proposal that we worked out last week that we would put forth that would allow for people who are convicted of a crime that requires registration but were sentenced to probation to serve 5 or fewer years in prison, or to a split sentence, which included serving 5 or fewer years in prison, but also meet the criteria set forth in this in 1710 6.2.
Two things.
Yes.
The first, the 5 or fewer years in prison. 5 is a big number. And what I'm curious about is, what offenses are we talking about with folks who have been sentenced, as a practical matter, who've been sentenced to 5 years? What charges are we looking at? Because if somebody's serving 5 years, to me, and speaking only for myself, they've done something pretty serious.
Right. There was great sentencing disparity throughout the state, particularly prior to 2006, when these crimes were raised to a level that this General Assembly took very seriously. And what we've found in exploring extensively the people who are on the registry is that you really can't tell by the label of the crime exactly what was involved in the offense. You actually have to look a lot deeper than that. And so what I would say is that you're going to have your situations of, you're going to have the statutory rape situations, you're going to have the things that fall into the Romeo and Juliet guidelines. But then you're also going to have these strange situations like our client that I just mentioned, who literally was convicted of being a party to a crime of statutory rape.
Don't we do better than to actually identify the actual crime, as opposed to, because if you have such great disparity, just dangerously thinking out loud, I mean, if you're going 5 or fewer years, that's a pretty wide range of possibility. Don't we do better by actually going to the actual crime itself?
If I may, I think the danger, and I could be anticipating, the danger with identifying the crimes, prior to 2006, the disparity in sentencing, if we go through, we'd have to enumerate so many crimes, and we may miss one. Mm-hmm. And I think to your point about this being, it gives you a bite at the apple, it doesn't guarantee you an actual. I think that's where the discretion of the judge comes in, because I do think that there's a danger to trying to enumerate every single crime and thereby missing something, which is part of the reason for creating this ability for the judge to have jurisdiction. And I think the second part of this would be that 5 or fewer years, it keeps us below that 10. I mean, there's a threshold where we know that what you've done is so egregious that we believe that you should be monitored. I think given the admitted disparity that exists in our state with applications to many crimes, I would argue that it makes sense to at least give you an opportunity to make your argument to the judge at 5 or fewer years, because we didn't have a threshold that said that 5 years means X. We do know that 10 years tends to signal something. We know that 20 years, 25 years, those numbers, when they become multiples, we know that they mean something. And while this is somewhat arbitrary, I think it is for me, it's a sort of a half measure. It gets you in the door to ask the question without necessarily guaranteeing you that you get an answer.
And your point is well taken. However, the concern that I have, and I think the concern that other members would have, is if you're opening it up to 5 years, I think what I would want to know, and perhaps what other members would want to know, is who are we talking about? Mm-hmm. You know, who are we really talking about? And I don't know if the AG's office can speak to that, or I see Judge Ray sitting minding his own business in the back of the room, you know, but unfortunately for him in the line of sight. I mean, what I would really want to know, and perhaps other members would as well, is who are we really talking about here? I mean, they've been sentenced to 5 or fewer years. What have these people done? And the question is the membership comfortable with allowing someone who has been convicted of X and they were sentenced to serve 5 or less to be able to go ahead and petition? Maybe, may not be. But I think in order to be able to make that determination, we have to individually and collectively know what it is that we're allowing to even have the opportunity to petition the Superior Court. Are you in a position to tell us what are we talking about, you know, in terms of the actual misconduct?
I'd have a hard time exactly listing. The one thing I can tell you is with 5 years, you're automatically eliminating 7 deadly sins, because you're not going to get a 5-year sentence for 7 deadly sin. You're eliminating anything with a minimum sentence of 10 years, and there are several that are in the bill. So you're starting off by talking sentences where you've got 5 years as part of your minimum. I don't know if I've got specific examples off the top of my head, but it certainly, I mean, it includes a wide range of things. I mean, you're talking, it includes the false imprisonments, it includes sodomy.
Well, hold on, Ms. Travis, let's let Ms. Westmoreland finish, and then we'll have plenty of time to for your rebuttal.
You'd have to sit here and go through some of these to figure out exactly which ones have that as part of the minimum,
right.
part of the sentencing range that you've got. So you just have to go back and look and see. There are a lot of them that simply won't be included in that because, as I said, the minimum sentence is either higher or you've got a mandatory
Right.
minimum to serve anyway.
What would be really helpful to members of the committee, I think, unless they shake their heads and say no, is perhaps to get a list of offenses that we're talking about that would be included within the proposed language. And again, we're not at a markup right now, but I think it's a good beginning point of discussion, which is not to say the amendment may or may not be adopted at some point, either in a substitute or an amendment to the actual substitute that comes forward. Regardless, and I think that'll help the committee get a hold on what that, again, going back to my comment before, what that threshold should be to allow for an individual who is a level 1 risk, number one, to be able to get evaluated to figure out if they're a level 1 or not, and then to petition the Superior Court, who will have the discretion to say yay or nay. Ms. Travis and then Mr. Ramsey.
The problem is that, and it also speaks to your what is a level 1. In this bill draft, this current bill draft, it just says you're a level 1. Doesn't list the crimes. But the tie-in that this amendment has, and also cohesion number 2 has, is it loops you back to the 1710 6.2C, which means, and which is why I was saying false imprisonment wouldn't qualify, because C1A, excuse me, C1E says the offense did not involve the transportation of the victim. And F says it's not physically restrained, so a false imprisonment could be a restraint. It may or may not be. So you could list the crime, but until you apply it to these circumstances as well, because let's just say it was a sodomy offense, there was no injury, it was an oral sodomy offense, and but there was a similar transaction. So you could list sodomy as being one of these criteria, but then you have to apply it to the person, and then it wipes it out because the person had a similar transaction, or they. Are you following?
I do.
Why just a list of crimes isn't going to be the answer to the question?
I do, but let me ask you. I will tell you that members of the committee are going to need to know. I mean, there has to be some sort of definition, and 5 or fewer doesn't reflect the definition. It reflects a number, which I understand is an attempt to get to the halfway point between nothing and something that's got a 10-year minimum. I get that. But my sense is that others, this room and other rooms, will need to know what are we really talking about. And that's what we just need to get to the bottom of.
If I may ask,
sure.
Would it be helpful to give you examples, but not necessarily? I think there's sort of the policy issue, and then there's the making sure we don't end up coming back to this provision after yet another lawsuit. And so what I'm wondering is it a question of, can we give you sufficient examples so you understand why, or so the committee and other persons will understand why this is necessary, or is it trying to find an actual statutory definition? Because I think the challenge we had, and I wanted to thank Ms. Travis for working with us on this, trying to find a statutory definition was so difficult because you've got to make it meet other exceptions that have already been carved into law.
An actual statutory definition may not be possible,
Okay.
and I understand that. Okay. What I also understand is that the number 5 or fewer may just be too expansive for the collective comfort level in allowing for the possibility for this petition. Now, and the word I used was may. So that's why we need to get a something of an understanding of the offenses that we're really talking about, understanding that there may be kickouts under Ms. Travis's point. I get that too. But we have to start somewhere with generally what are we talking about. That may be a conversation with the prosecutors, as opposed to the AG's office in terms of, what's happening when. I referred to Judge Ray earlier. He's the one handing out these sentences. So we'll need to get some little tighter, not definition, but a much clearer idea of what we're really talking about for those individuals who are getting 5. I know you want to get Mr. Ramsey.
Oh, actually, I was going to say thank you. I was simply asking for clarification. I'm happy to work on expanding that.
Sure. Mr. Ramsey.
And I just want to associate myself with your question about setting it at a kind of an arbitrary sentencing year threshold. From a personal comfort level, I'm going to need a lot more information. I recognize the challenges of making it offense specific, but at least with the offenses, we know the elements. We know what types of crime we're talking about. And maybe I can get more comfortable when we get some information back from Ms. Abrams and the folks she's working with. But I agree with the chairman that I think that we hear that question asked over and over and over again if this was adopted as is right now. And I have a broader question, not on the language proposed by Representative Abrams is now the appropriate time, just on the whole Section 9.
Sure.
The process, the hearing process that we're setting out, it names the sheriff as the defendant in the petition and sets out what kind of evidence will be offered before the judge. And I know we're working on a victim's rights bill, but I offer this as food for thought. Should we require that the victim of the crime in which the person was put on the registry to begin with be given notice of such hearing? And I offer that up. I know we're not voting or amending the bill today, but it would seem it seemed like something we'd really strongly consider, given the whole premise of the registry to put the victim on notice, to allow them to participate in that hearing process, to put the information before the court so the judge has heard from every possible side. I mean, right now it's just the sheriff and the petitioner themselves that are going to be there, and I think it'd be prudent to at least consider between now and the next meeting including the victim in that process.
Are you referring to a simple notification, or notification and then having the standing
I think they need to be given the opportunity, and it might be administratively challenging or impossible, but I offer it up as food for thought, and it's something I'm going to think about between now and the next meeting. Okay. It's something I think the committee should consider.
Thank you. Ms. Benfield, then we'll come around.
Yeah, I wanted to know, does the minimum mandatory sentencing requirements apply to party to a crime? I should know that. But if you're convicted of being a party to a rape, the 10 years minimum mandatory apply?
You're convicted of rape.
You're convicted of rape.
Okay. Because I was just wondering, the party to scenario that you presented, I can think of a couple of party to scenarios where the offense itself is very serious if you're a party to a rape. But you could be a party to a rape, I'm assuming, if you are a spectator to the rape and somehow encourage the rape, and certainly involved on a much lesser level. And so I could think of some scenarios where the offense itself is very serious, but the party to be a lot less serious of an offense, and you might want to have them considered.
It would still be a rape conviction as a party to.
You still get the minimum mandatory. Okay, thank you.
Mr. Levitas.
points, Mr. Chairman. The first is, following up on Representative Benfield's comments, I think one could at least make an argument that the parent in that case who allows that criminal act to occur under his or her supervision is appropriately charged at the same level as the person who committed the act if they have knowledge of it. But that's probably a discussion for a different day. Where you get the half sentences, I believe attempt is the one where it's punishable by up to half of the maximum. I want to go back to a point I raised earlier because it kept bothering me, and so I looked it up and wanted to convince myself that it's correct. In the 10 years or fewer, when the judge has discretion under 1710.5 to sentences for a misdemeanor, it does not change the nature of the crime. It is still a felony. It just is punished as a misdemeanor. Because I thought I understood you to say that it becomes a misdemeanor, but it still always stays as a felony. And I guess with the bill, does this capture those offenses? In other words, just because somebody in enticing a child is sentenced as a misdemeanor, even though they are in fact a felon, they would still be required to register under this, or would they be exempt from registering under this?
The current law excludes people who are, I believe, in Joe, the phrasing is sentenced as for a misdemeanor.
That's
the
current law.
Then that's a real big issue I have. There's one thing when you're talking about a Janarla Wilson case, but if somebody's been convicted of a predatory crime and for whatever reason the judge reduces it or sentences it as a misdemeanor, we should be capturing those people, especially if it's happened on more than one occasion. So I would ask you to revisit that particular issue. Because if the only difference is a judge who, for whatever reason, may be a valid reason, or it may be the judge is a very liberal sentencer and just doesn't like the fact that there's a 10-year sentencer and doesn't want this person to walk around with a felony sentence, we need to revisit that because we need to make sure we're capturing the people that are intended to be captured by this and not just base it on how some judge has decided to sentence in the case.
The only point we have made on that code section dealing with misdemeanors is you're treating the categories of people differently. You're based on the date of the conviction, and that's the only basis. And whether you want to register all misdemeanors or no misdemeanors, that's a policy question.
But I think his point is that they're not actually misdemeanors. It's the conduct
Correct.
itself was
But
felonious
again,
conduct, but punished as a misdemeanor.
And like I said, that's
Right.
the current law is punished
Right.
as for a misdemeanor.
And I'm asking,
And just to be clear, the Attorney General's office is not advocating or not advocating one or the other. They're just simply stating what the current state of the law is or not.
Absolutely.
You can change it to misdemeanors and take out the punished as for, and which gets a little bit more complicated under the way our system works. But
Well, and I guess I'd ask for your help, maybe outside of the committee, to work on language like that, because obviously, what my concern is about that.
Yes.
Ms. Benfield.
I think I just need to see Title 17, but I just want to make sure I understand the rest of that subsection and meets the criteria set forth in those subparagraphs of 17. Thank you. So that might address some of the concerns.
We'll take a look at it, and then we'll go to the next section. We can always come back. All right. I think we've got a lot of the conversation that was generated on that removal provision was good, and I think it gives us a roadmap for what issues have to be hashed through in order to get to a point where there'll be a comfort level on the possibility of a petitioning of certain level 1 risks to the Superior Court, and the Superior Court in its discretion may grant it, not grant it, tell the petitioner to come back at a time certain. But I think we have some work to do on that. Let me, the next topic is penalties, and this goes to the Bradshaw case. This goes to what had been a life sentence for a second offense for failure to comply with the registration requirements. Our law had been, if you're convicted of failure to, on a second offense, of failure to comply with the registration requirements, you got life imprisonment. The Supreme Court struck that down as a violation of Eighth Amendment cruel and unusual punishment. What the language in the substitute proposes to do is to leave the first, is to have the second offense mirror the first offense, and that would be 10 to 30. Am I saying that correctly? 10 to 30, which again mirrors the first offense. That would still be the strongest in the nation. I think we would share that with one or two other states. But I believe, in my opinion, would go ahead and pass judicial scrutiny as not being violative of the Eighth Amendment. but still preserving the underlying tenet of the seriousness of the registration requirement. Ms. Abrams.
And we talked about this last year. I think that given this is a first offense for failure to register, it strikes me that 10 years as a minimum sentence for a first offense is remarkably strong, and that this is a fairly complicated law that will require a great deal, and I think we're doing a strong job of amending it. But last year we did, I think, reach the place where we were willing to reduce that 10 to 1, still leave the opportunity to make it 1 to 30, but you are dealing with first, I mean, no matter who you are, even if you are able to petition to get off, you could be a level 1 registrant who is sentenced to 10 years. Basically, you could be sentenced to a higher penalty than you may have actually received for the offense of the crime. And I think that's deeply problematic, and would argue or would ask for this committee to consider whether or not we should again return to the notion that setting the threshold at 1 year with the opportunity to go up to 30 years recognizes that you have a fairly wide range of persons who would be captured under the registry requirements.
Thank you. Mr. Levitas.
Yeah, following up on that comment, I will point out, and I know that one of the members here was the dissenting vote there, but last year when we considered SB 157, which was the Senate version of the registry bill, we actually changed that on lines 118 to 121 and changed it from 10 to 1 and 30 to 10, and then for a second conviction had 5 to 20. So I'll just point that out when the committee's considering that we actually took action in that regard last year.
It's all up for discussion. I mean, you know, we went through an amendment process on 157. My sense is that we'll go through an amendment process on this. Only cautionary note I'd make to members is that, you know, it's a balance. It's a fine line between making a law more functionally operational while at the same time not weakening its underlying tenets. Now, there may be philosophical disagreements on those underlying tenets, and I understand that, and more importantly, respect it. It's a matter, to me, it's a matter of having the law make sense, but also keeping it strong. And the question is how strong. Okay. Any further comments on the Bradshaw piece? Okay. The next section has to do with the Sex Offender Registration Review Board. I won't go through this entire summary on this particular section. I know that the board went through some procedural challenges last year. There have been some due process challenges raised in courts for procedural problems. And they've enacted certain rules, which I know Ms. Strickland will go ahead and talk about when she comes up. Section 7 will go ahead and address some of the procedural matters, but also the change the individuals reviewed by the board. Specifically, in lines 159 to 174 adds to those that the board has to classify any sexual offender changing residence to Georgia from another state or territory who has not already been designated a sexually dangerous predator. An individual is referred by a superior court considering a petition for removal under the new section. And what this will, I think this sort of partners with the removal section from before, is that we go ahead and define who's, you know, eligible for leveling to petition off. This will allow the superior court, as I understand it, to order that that evaluation to occur, so the superior court can know, is this person a level 1 or are they not a level 1, and as a result be able to make a decision on the petition. (194 to 196), the time period for which the board is to classify those moving into the state. 197 to 199, the time period in which the board is to classify those referred by a superior court under the removal petition section. Notifications, lines 202 to 206, notification to the offender by first-class mail. into the GBI and the sheriff. (207) to 241, the procedure for a challenge of the board's classification, allowing for a reevaluation of level 2 or predator classifications and an opportunity for the offender to be heard by the board. And then 242 to 259, judicial review for level 2 and predators, time limits, venue, etc. I mean, this gets into the procedural dynamics of what happens when with regard to the court's review of an individual who we would define as meeting the criteria necessary for a petition, and then the ability of the court, if that person has not yet been evaluated, which my sense is they would not, given the backlog that I understand that they currently experience, would allow the court to go ahead and mandate that as part of their consideration of the petition. Any questions about that? More the procedural dynamics of the petitioning scenario. Ms. Benfield.
Just a quick question, subsection C on page 8. Why is venue in the county, Superior Court of the county, where the offices of the board are located instead of where the defendant resides?
So
I'm assuming that's all one county. Would that be Fulton?
That would be Fulton.
And
currently.
I don't know if there's a big, if this is this would be a heavy caseload for Fulton. I'm just curious why it wouldn't be in the county.
That's more of an
That's
isn't that
actually an
more of
issue?
an efficiency?
It's an efficiency issue. Currently, you consider we have 159 counties, and that requires it requires two things. It requires members of the board to go to the hearing to testify, thus cases are not getting leveled while they're gone, and us to go defend it if that's what's happening. It was an efficiency issue to pull them all into one place.
And the suit is generally filed against the Sex Offender Registration Review Board.
Sure.
Under this, so where it is located fits in with Georgia law. Right now, there is no provision about who you petition, how you petition, where you petition. So petitions are taking place all over the state, not naming parties who may be appropriate, sometimes not even naming the Sex Offender Registration Review Board. There's an attempt to sort of pull it together and have some uniformity to it.
You know, where does it happen? Who has, who gets petitioned? Who has to show up on behalf of the state?
That's correct.
I mean, my secondhand understanding is right now they're happening all over the state, and it's not really clear as to who's responsible to show up as a respondent, right?
That's correct.
Okay.
That's correct. And people petitioning don't have any idea who to name as a respondent. So this is attempting to, provide some clarity for that entire procedure.
And to treat the review of this board's decision similar to other decisions. The parole board, for example, parole board declining to parole, they get sued in Fulton County. They may get a mandamus petition in Fulton County because that's where the board is. It's the board's action that you're challenging. This is the leveling process that we're talking about. And the entity doing the leveling is SORB, the review board. So that, and again, it was an efficiency question and getting it where the board is.
I'm just curious, quick follow-up. I mean, how many of these are filed a year? Are we talking about a large number that Fulton County courts would be handling, or just a handful a year?
Potentially, there could be a relatively large number. Our experience so far is 10 or 20 a year that we're aware of thus far.
I mean, currently the people doing the challenging of those leveled as predators. I mean, this would add you to level 2s and the predators. And at the rate of leveling, I don't see that as being an overwhelming number of cases. I don't know that we have a good way to tell just yet.
Thanks.
Mr. Everson.
Thank you, Mr. Chairman. In regards to the removal petitions being filed and the Superior Court judge rules against the petition, I notice you have established a 2-year time frame in which they cannot reapply. Why 2 versus 5 years?
Policy question, pure and simple.
Thank you.
All right. piece on restrictions on those required to register, that's just a cosmetic, not cosmetic, but that's a structural change, individual to person, as individuals already defined. Okay. That's just definitional. Okay.
Clarifying a definition.
Volunteers, it's an issue that's gotten some attention. We're currently defending a class action, Whitaker versus Purdue. The challenge of the prohibition on offenders being volunteers is being vague and run afoul of the First Amendment as it relates to religious institutions. And so what the substitute proposes to do in lines 317 to 324 is to establish a definition of volunteer. I'd invite committee members to take a look at it. It still will provide for an individual to engage in volunteer activities subject to certain limitations that won't surprise you, related to certain interactions. I think that's pretty straightforward. Any questions on the volunteer issue? Okay. Property interest. We had a case, Mann versus Department of Corrections. This is the issue where you had it tackled the issue where you had an individual who was an offender on the registry who was living in a house, and I wouldn't say a condition, but the scenario of sort of came to them as opposed to them going to this to the scenario, for lack of a better description.
That's correct.
And so they were there first, is what it comes down to.
Yes.
And what the court ruled is that you could not go ahead and apply certain requirements on that individual if the condition came to them, as opposed to them moving into an area and then having conditions be made applicable to them. And these are the residency and employment restrictions. The court ruled that would be a taking of property. And this issue that we're tackling right now has to, what we propose to do in lines 329, 363 is to tackle that issue as it relates to renters, leaseholds, because leaseholds under Georgia law are still property interests. It's not just a function of ownership that a leasehold interest would have applicability in that situation as well, correct?
That's correct.
Okay. So what this would do is simply make the change to make that precedent whereby if the condition, if that individual property interest owner, whether it's an owner or a leasehold, if the person had a leasehold interest or renter, if the condition came to them, that they would be protected.
That's correct.
Where they, I should say not protected, but the residency and employment restrictions would not have applicability to them.
This is to conform to the decision.
Conform to the Mann decision. Okay. Mr. Franklin.
What happens in our current law in relation to the employment? If thankfully in Georgia the business grows and they have outgrown their current business location, and the business moves into an area where you're within a certain distance, what happens to the person on the registry in a situation like that, where the business moves, the employment moves into a prohibited zone?
I would think the prohibitions would kick in at that point because the condition is moving. In other words, they're moving to the scenario where there may be a school or whatever the prohibition is. I think at that point the prohibitions would kick in.
That's correct.
Right. So the employee who's captured under what we're doing here would basically have to seek new employment at that point if the employer moves the business.
That's my understanding.
Under existing law, that is correct.
Okay, thank you.
Ms. Abrams.
Having raised that, can we explore language that would fix that problem? Because I do think that we are setting ourselves up. I think what Mr. Franklin is getting to, the fact that you would lose employment by virtue of a decision you had no choice in making, particularly in an economic climate such as this, would strike me as slightly problematic. And again, I do understand the intent, but I think that we have to be very careful not to create new problems for both the implementation of this law, but also for people who are attempting to comply with the provisions of the law.
And that really gets into that's a policy matter that really goes, to me, it goes to the priority. So what is the priority? I mean, you're balancing the safety interest that occurs when the business is moving to this new location, which is within whatever number of feet of a school or whatever the condition is. And you're balancing the safety priority, which is one of the underlying tenets of the bill, or the existing law, I should say, versus the ability of that individual to maintain employment.
I agree, and I think that
I'm not editorializing on that. I'm just
no,
trying
absolutely.
to frame that as the struggle.
Absolutely, but I would add into that there's also the intent of the law to recognize that there are decisions that are made by the actor and there are decisions that are not within the actor's control. Mm-hmm. And I think that's the other part of this equation. We've set up a fairly rigid structure, and I think we're refining it, but we've set up a structure that it tends to be more expansive than restrictive. And when you are no longer responsible for when you don't have absolute control or even nominal control over the decision making, I doubt the employee who would be in this situation would have any choice or ability to determine where the business is relocating. And so I do think that's absolutely the proper framework. I would just add another dimension to the framework of the control of the actor to make decisions, because part of this is to restrict the ability of the actor to make decisions that could endanger others. And I think it's important for us to recognize that it's not always within the purview of the actor. And I think that goes to the conversation about people who are in hospice care and nursing homes. It's a slightly different approach to it, but it's the same underlying concern, which is when do you have control over your ability to endanger the lives or the welfare of others?
I don't disagree that it's a control issue. The issue really is that relevant? Is that yes, it is that individual does not have control over where that business moves. I don't disagree with that. The question is, but that for me, does that? I'm not going to say it doesn't matter. I'm going to say that really doesn't touch the underlying safety concern as it relates to that individual now being within a certain geographic area or that poses a potential public safety threat. And I'm not sure the control issue really operates. It's an unfortunate circumstance for that person from an employment standpoint, but it doesn't change the underlying safety argument, and that's just a judgment call.
I would agree. I would still request that we look at language that could.
We'll look at it all.
Can I add one thing to
Sure.
that, Mr. Chairman?
Sure.
And the one thing about that I don't know that was touched on with the removal section that is in here, it does authorize the judge to do a removal from only the residency or employment restrictions and not take somebody off the registry. So if in that circumstance, if somebody fits under the criteria for seeking removal, they could the draft would allow somebody to go in and seek removal from the employment restrictions. If they fit the other criteria, that's
it's not an all or nothing proposition.
Yeah,
it can be all or part of the restrictions.
Right.
That currently exist under the
Okay, and that was my point too. I think that was Mr. Franklin's point as well, that if there's an absolutist approach to this, I do think we run the risk of being overly expansive. But if there's an opportunity for remedy, I think that's
and that might be the place to look at, and to balance out the public safety. I mean, there are people that, and again, this is a policy question, but that might be the way to deal with that, is to look at the removal provisions to see if there's a limited circumstance under which you want to authorize a judge to say you're not subject to employment restrictions. And I don't know, but that's just.
I think I read that in the petition language that it provides the Superior Court the ability to remove all or part of the restrictions.
Right.
So, and if that condition comes up, now I'm not going to say it makes it an easy process to all of a sudden your employer moves. You don't get a whole lot of notice, although probably more than one would think.
Right.
Then you have a petition situation. Does that neatly match up time-wise? Probably not. But I think that you said it right, that the remedy would exist under the petition scenario.
I think.
But the problem with that is, again, how and in 1960 or 1970, and now the change is 4 years. So, in your assume you change it to 4 years, that person wouldn't be able to petition because he doesn't fit the initial criteria.
Because they.
So that's why it is a possibility, but it's going to depend on what y'all put in the criteria.
Right, and that, I hear you loud and clear, and that criteria is really where the rubber hits the road on this issue. And it's the threshold judgment of who, if the committee even wants to go there, about who would have the ability to petition. That's why I think the request that I think I made and others made as well, that we need to get a list of who we're really talking about here, because I think there's a disconnect on the scenarios we're talking about, because those scenarios go to the comfort level of the ability of members to say, okay, this is an individual who made one mistake, paid the price, they've been determined as to not be a threat to society. Should they have the ability to petition the Superior Court to come off that list or not? We can't answer that question unless we really know who we're talking about, and we just don't know yet. But we're going to find out. Okay. Any other questions on either Ms. Abrams' point or on the property interest topic having to do with Mann versus Department of Corrections? Okay. Let's do this. It's 11:45 right now. Let's take 45 minutes for lunch, and we'll come back at 12:30 for those who can. Again, this is a hearing only for those members who can come back. We'll come back and take testimony. We only have 3 witnesses. That's not to say they will any or all will be brief, but that's okay. But they're very relevant individuals on this topic. We'll go ahead and plan on doing that from 12:30 to 2:30. So let's break for lunch, come back at 12:30. Terry Norris represents the Georgia Sheriff's Association. Normally I would direct this comment to all members who are here, and they may be, but when they trickle back, we do have a copy of what you dropped off last week. These are the recommended amendments to the substitute on HB 571. I've taken a look at it. I don't know if you want to speak to that or not, Mr. Norris. You don't have to. However you want to address it from an issue by issue is fine with me. It's up to you.
Thank you, Mr. Chairman and absent members. It's nice to be with you today. Thank you for giving us an opportunity.
And for those who may be viewing on the internet, this is a recess day, and members do have there are other conflicts. The members of the DeKalb delegation had to excuse themselves for a delegation meeting regarding the census, which of course is a serious matter. But so we may have some come in or come out, but we do want to get these issues out there for the record, so that we can keep on working on this substitute and truly perfect it to the extent that we can. So I'm sorry for the interruption, but I want to make sure that was clear for all those observing.
Thank you, Mr. Chairman. Again, Mr. Chairman, I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association. We've been, the sheriffs have been the group probably most responsible for the boots on the ground, handling the registration and tracking of monitoring of sex offenders since 1996, even in the law that predates the current law. So we have a little experience in this area. What I'd like to do, if it's okay with you, is just sort of go issue by issue. There's
Sure.
not that many. Thank you for accepting the document the other day. If it pleases you, Mr. Chairman, I'd like to direct you to page 2, line 52. It deals with the sheriff's ability to collect the address of more beyond just the address of residence. What happens a lot of times now is you've got an offender that may list his address of his mother's house or his father's house, but yet he may have a girlfriend or she may have a boyfriend, and they may stay at a residence that's not the residence of record. And we'd like in the law to prescribe that we're allowed to collect those additional residences. And I think the old language may have done that. I don't know if there was a reason to exclude that.
Maybe that was to try to get a handle on primary residence. I'm just speculating. I don't know. But, you know, you mentioned boots on the ground. I mean, where words on paper meet implementation is not always a smooth matter. So I think we want to err on the side of something that's going to be operationally effective. And so we welcome your comments on that.
That actually, that one point there, and there'll be one or two more, actually means more work for us. But in our efforts to track and maintain a record of where folks are out there that need to be watched, we thought that'd be good if we could leave that in.
Okay.
On page 4, line 107. Well, I kind of stuck it here, but one thing that we'd like to see, and you're going to have to add.
Now tell me where you were.
I'm talking about multiple county registration. I was in the bill here. I was at 107.
Okay.
It's just somewhere in that area. I don't think you'll find the language specific, but we'd like to see multiple county registration required. In other words, we'd like to see the offender register in the county where they reside. We'd like to see, if appropriate, that person going to college in a different county. We'd like to have registration in that county with that sheriff. And then if there's a third county where someone works, you could conceivably have registration in 3 counties. We think it gives us a better opportunity to watch and monitor the movement of these individuals.
From an enforcement standpoint, I mean, I can understand from a monitoring standpoint, in terms of your ability practically to have that happen. What are the realistic chances of that? And you can speak to that better than.
Well, essentially, the primary registration is going to be the county residence.
Mm-hmm.
That's the most important. But
right.
Yet, if County B, if the person is going to school at County B, that person just simply advises that sheriff office in County B that I'm attending the Cab Tech if I live in Rockdale, and then again if I'm working somewhere else, and it allows the sheriffs and the deputy sheriffs, they want to do this. They want to be able to determine whether these individuals are living, working, going to school in areas that are excluded from some restriction in the code. So multiple county will require more work on our part, but it is something they feel is appropriate, and they are certainly willing to do.
And that's item number 3 on your proposed amendments?
I'm actually not working from that document.
Sleeps, is employed, or attends an institution of higher education?
Right.
Basically residence, employment, school?
Yes, sir.
Okay.
Yes, sir.
Yes, ma'am. Mm-hmm.
Like, let's say a person's going to Kennesaw, and now they're going to go to Gwinnett, and what time frame you're going to have to change, and who you're going to let know. So there's a domino, not as simple.
Okay. We'll take a look at it.
Since you're on my document.
And we can go back and forth however you want to. I'm going to relate it back just to make sure I've got to match up with what your proposed amendments are within the bill itself.
Okay.
Okay.
If you'll look at the bill itself, page 4, lines 118, 119, that's just kind of the area we're thinking about. And you talk about homeless offenders, and you talk about, under the current language, I think we're holding them to the same standard that we are holding offenders with a known address. Those offenders with known addresses must give a 72-hour notice prior to moving to the sheriff in the county where they reside, and then to the county they're moving to within 72 hours after moving. We think actually it's a little unreasonable to offer that same expectation to a homeless person. So because
they don't know whether they're going to be within 72 hours. So they don't know where they may be from an hour to
within
hour.
72 hours, we think would be a good thing for that point. Of course, still on the same page, page 4, line 122, that $250 fee. I can't tell you today with certainty. We can check with Department of Audits and Treasury as to how much money has actually been collected since day one, but there's not very much that gets collected under this provision. And we'd simply like to see that provision excluded.
Is that more of an administrative burden than it's worth?
I mean, it's fruitless. I mean, you're requiring by keeping this provision in there, you're almost requiring the sheriff to determine indigency in cases, and we're not prepared to do that. The other side of that is, and again, there's not much being collected. There are some states, I will tell you, and it does mention it in my document, that collect a small amount, and that money is retained at the local level to help monitor sex offenders. But I mean, I didn't include that other than that as a note. Page 4, 125, 126. Currently, if you're a sex offender, you're incarcerated, you're still required to register. And it is absolutely impossible for the offender to comply with the law, and even for the sheriff to comply with the law on that registration if they're in prison. Now, we have suggested before just eliminating that, including ensuing periods of incarceration. But, you know, I'm of the opinion, and I don't think corrections is here today, they may be, I'm of the opinion they're already keeping this some way. So if they're incarcerated, they're in prison, we know where they are, number
by
one.
definition, they are monitored.
Right, and we can access that information. So it really does create a problem for the sheriffs who try to comply with the law. This is impossible.
Okay. Yeah, I mean, at the very least, that's duplicative and more of a burden than you all need at that point, since they're already in the system. Correct?
Yes, sir.
Okay.
Page 5, we kind of stuck it at, right before, I guess, line 143, somewhere in there. Currently, when there's a change of registration information and the sheriff receives that change, the sheriff then reports that to GCIC or GBI within 2 working days. We'd just like to see that move to 72 hours to try to offer some consistency on reporting throughout the document.
Tell me the line again.
Actually, I stuck it. It's not in the bill.
Oh, okay. Could you repeat that for me?
Oh, yes, sir. We'd just like to see that when you're updating the registration information from the sheriff to the GCIC or GBI, we'd like to have that, us to be able to do that within 72 hours as opposed to the current language in the law, which is, I think, 2 working days.
Okay. Okay.
And also, you won't find it in the bill, but we would like to see the language cleared up to say that we can, actually it may be in the bill, but we can report information electronically to all these entities that must be reported to.
Okay. All right.
I'm moving on. Somewhere on page 9, I guess, around the end of section 7, we'd like to have some language, and there's no language in there, I don't think, at this point, that would create a felony offense for tampering with the electronic monitoring device of the predators. I think that's a pretty...
There is a code section on that. It's in Title 16.
Does it include the sex offenders, though, or is it just in general?
Any electronic monitoring. I can check on that.
You can just confirm that. That'd be great.
Well, that would suit us as well.
Thank you, Mr. Travis.
On, and you won't find this in here, it's in my document, but I think it's under number 2. Presently, Mr. Chairman, you've got some individuals that max out. They're not paroled, they're not serving a split sentence where they get out under some sort of supervised release. In those instances, particularly if the individual is homeless, where they don't have anywhere to go, and they won't tell you where they're going because they don't know. We'd like to see at least some discussion about requiring that offender to, as soon as they're released under a max out, to go directly to the sheriff in the county where that institution is located and at least start that registration process at that point. Because heretofore, that we have no authority under law to keep that person after the max out date. We're done with them. So there's no incentive sometimes for those folks to give them any information, particularly if they're homeless.
Oh, I see.
Not that they even know. They don't know. So if we could at least start the ball rolling, for instance, Jackson Diagnostic and Classification Center, if they're getting out there, and you don't tell the corrections officials where your residence is going to be or what county you're going to live in, then the first place you go is the Butts County Sheriff's Office when you get out. And you make that first initial registration. And I don't know, Joe Drolet and others probably could speak to this whole venue thing. That would, in our opinion, establish some venue so that if that person failed to meet registration requirements, you'd have some way to start the process going with a warrant or whatever.
Do you have specific language that you to go with what you're addressing?
I do, but I don't think we've perfected it to our. If it suits you,
okay.
I'd
We'll look for that
Joe
this week, maybe.
Okay,
that'd be great.
Finally, page 11, line 382, Mr. Chairman. This seems to involve the process by which one attempts to be removed from the registry. And we certainly have great concern that paragraph 2 at the end names the sheriff as the defendant in this particular instance, since we have no responsibility over placing folks on or taking folks off the registry.
Do you have a suggestion?
How about the state of Georgia? And sir, that was all I had.
Okay. Thank you. What we'll do is, if there's any additional language that you want to submit for consideration for the next substitute, I'd ask you to please get it in within the next few days,
yes,
if you could. Ideally, I mean, it would be great to have a substitute ready for motion by the end of the month, and that's the aspirational goal, which I think we can get there. So the quicker we can get that, any suggested language, it'll give us the opportunity to see how we can best make it fit, if we can make it fit.
By the end of the week, sir.
Thank you.
Thank you.
Okay. Susan Strickland. Welcome.
Not necessarily here to speak on behalf of the Sex Offender Registration Review Board.
Okay.
Faye Chastain or Angie Holt, our chairperson, can speak to any questions that you may have for them about that. I was actually here to talk about what we've talked about before, and I've talked with many members about, is differentiating the residency restrictions for level 1 from level 2 in the sexually dangerous predators by reducing the foot requirement from 1,000 feet to 500 feet for level 1 offenders.
Do we address that issue by virtue, I mean, I understand what you're saying. Do we address that issue by virtue of having the petitioning section for the level 1s to begin with, so that they might, depending on...
Right, but we don't address it from the prison standpoint or from release, because they have to be in the community first before they can petition the board to be level 1 or to appeal the board decision on them.
Right.
So what happens is we have a backlog in our prison system of low-risk offenders who can't find addresses to parole out to, and housing is the #1 issue that we're getting stuck with, the low-risk offenders. And as our numbers are looking, 75% of the offenders are level 1 offenders.
75% are level 1 offenders.
Mm-hmm. Within our state and nationally.
Would a possible alternative to, rather than reducing the residency requirement, or the residency restrictions, would a possible logistical alternative be to have that leveling, to allow for the petitioning for the level 1 offender occur at the end of incarceration prior to release? Is that a realistic scenario?
I don't know. I haven't really thought that whole process out.
Because that way you have the restrictions in place, but for those individuals...
They're not going to have an attorney at that point to do that for them, so they'd have to make contact with the court themselves and do the petition from the prison. So I don't know how that would work. I mean, I can't speak to how it would work logistically.
So your main concern is the fact that there may, assuming that there is a petitioning mechanism for the level 1 offender post-release, you've still got that in between time, the time that they're released and the time that their petition actually is considered by the Superior Court, where those particular where the restrictions as they are now are in effect.
Right, and they can't parole out or be released out or have an address because the 1,000 foot is so prohibitive from all kinds of places. And if you talk with sheriffs or anybody, officers and stuff out in the community, the 1,000 foot from churches, playgrounds, all of that, for level ones, we still don't want them living next door to any of those facilities, but 1,000 feet from them really excludes many, many, many places for offenders to live.
What is the state right now of the ability to find such a place within those restrictions? In other words, I'm under the impression those locations exist. There aren't many of them. Can you?
The other thing that happens, I can't specific. God bless you. I don't know the answer to that, except to say that one of the things that happens is that you push offenders further into the middle of neighborhoods rather than on the outside, closer to MARTA, closer to commercial areas, because commercial areas are where churches and so they're in the middle of neighborhoods, in the middle of subdivisions, kind of back in the middle of places where there's more access to get out of the neighborhood to children than if they lived closer to the commercial areas. So because the 1,000 feet from the boundary of a church or a school or the property is a long way.
I think you said you were unaware. Are there not designated locations, but are there facilities that have been not built but exist, centers, halfway house type of places in certain places, whether in metro or statewide, where these individuals are in compliance with the geographic restrictions?
I'm sure there are those that exist. One of the problems is that the other policy is that we don't like them to live together often, and so we don't want a bunch or a group of sex offenders living together. So we try to minimize the number that live in a facility, a halfway house, that sort of thing. So they have to live on their own in a community somewhere, and we're talking about level ones. We're only talking about level one offenders, which are the low risk offenders, which we all talked about earlier, are the ones that should have the right to even petition to get off of all of that.
Let's talk about the level one offenders for a second, because we have an idea of what we believe a level one offender to be. I'd like you to put a finer point on what is a level one offender. And I know you said before that 75% of such offenders are level one offenders. Give us a clearer definition of not who we're talking about, but what offenses we're talking about. Are these individuals with one conviction? Are the individuals with multiple convictions but still are found to be level one offenders? Give us a clearer definition, if you can, as to who and what we're talking about, because that goes directly to the issue of the individual's ability potentially to petition the sentencing court to potentially come off the registry.
Right.
My sense of it is that the membership from both sides would look at it, in terms of the one-time offender. The one-time, they're all serious charges, certainly, but the one-time offender further down the scale in terms of seriousness of offense, where there was no victim, where there is no physical harm, etc. And a lot of the provisions that we already haven't set out in code, minus obviously the 10 years after the term of probation. That's what we're really talking about. But the question is, and this goes to the issue that we talked about before, about what do you include? What is the threshold? Maybe the answer is to include what it's not. Right. Maybe the answer is to include what it is. But we still have to get an idea as to the offenses we're talking about, so we can be comfortable.
Right, and there's a difference between talking about the name of the offense and risk for recidivism. And so when we're talking about risk, and we're talking about the risk to recidivate, to do something again, that doesn't necessarily get designated within the name of an offense. So when you ask the question, what does a level 1 sex offender look like? Well, there are other characteristics other than the offense. So it could be rape.
And just to be clear for the record, when I say what does level 1 look like, I'm not talking about the physical. What does the physical person look like?
I understand that.
That's obviously irrelevant. It is, what are the characteristics? What are the behaviors, past, present? Is it a one-time offender who's had no problem, during incarceration and presents no threat? Is it a minimal threat? What's the difference? And I'm sorry for the interruption, but I want that to be clear.
Sure, absolutely, sir. That is the question that we deal with at the Registration Review Board, is looking at the differentials between what makes an offender a level 1, level 2, or sexually dangerous predator. And we use actuarial instruments to look at characteristics of offenders to come up with what that profile looks like. And you are correct that one of the characteristics is one-time offense. Offenders that have more than one offense, whether it's a sex offense or other criminal offenses, would fall into the category of level 2, along with age, along with relationships, marriages, relationship status, along with juvenile record, along with, we divide them into static characteristics, which are those things that do not change, and dynamic factors, which do change with treatment or with interventions of some sort. So a level 1 offender could be someone who committed child molestation within the family, and it's a one-time offense, or a series of offenses against one victim. An incest offender would be oftentimes a low-risk offender, or level 1 offender, because they don't have a history of acting out, they don't have a history of sexual acting out or criminal acting out, they don't have a history of crime, of risk factors that are including stranger, that increases risk, same-sex victims increase risk. So those are some characteristics that differentiate a low-risk level 1 offender from higher-risk offenders.
The 75% that you mentioned that currently are level 1 offenders, do you have any data as to what level do those 75% level 1 offenders, or just level 1 offenders in general, commit an offense, another offense, commit multiple offenses as opposed to a single offense?
Okay, if you're asking, do we have any data that looks at level 1s designated in Georgia by the review board, and how many of them have committed a second offense subsequent to being leveled 1?
Correct.
We do not have that data. We could get that data.
How?
Corrections, see if they've been arrested again.
Okay. You've participated in X number of evaluations of these individuals.
Yes, sir.
Okay. From what you've seen, and this will be simply your experience as opposed to any kind of data needs to be taken as such for the record, what is your sense on, from what you're experiencing, the individuals that you've personally evaluated, in terms of these individuals being multiple offenders?
Level 1 offenders?
Yes.
The risk of level 1 offenders recidivating is very low. The majority of them, now of course we don't have a magic bullet to say all of them will not reoffend.
Understood.
The majority of them, the vast majority of them, do not reoffend. In fact, of all sex offenders, only 5 to 15% reoffend, of all sex offenders, not designated by levels. So the recidivism rates of sex offenders is low anyway compared to other offenses, other crimes. But level 1 offenders, when we designate them 1, 2, and 3 predator, are significantly different. Now, I cannot right this minute produce to you what those numbers look like with our numbers since '06 to now. We could try to put those together and see what they look like. How many level 1s have recidivated, how many level 2s have recidivated, and what's our recidivism rate for the predators that we've designated predators.
If we were to go ahead and have a system and have a situation where a one-time offender would be given the opportunity to, and I'm not saying all one-time offenders within certain parameters that we have yet to define, so I know that's a little bit theoretical, but one-time offenders within a certain parameter, I need to think about that question a little bit more. Ms. Cooper?
Are there national figures?
Sure, yes.
Let me ask you to bring the mic closer to you if you could.
What are the national figures of them, of a level 1 committing another crime?
Well, I can get those for you. They're everywhere, and I can get several of the latest studies. But level 1 offenders, low risk offenders that score low on the static 2002 or static 99, which are the instruments that are generally used throughout the country, are very, very low. And then there are subsets of offenders, like incest offenders that molest or have inappropriate sexual contact within the home, that are lower risk offenders. The higher risk offenders are those that have multiple offenses and behave inappropriately outside of the home. That are the higher level ones that we're trying to catch with the residency restrictions, that we're trying to reduce their proximity to children. The residency restrictions do nothing to reduce proximity to children in the home. And children are more in danger in the home than anywhere else. Stepfathers, boyfriends, aunts, uncles, folks like that. So yes, we can definitely get this committee any of those numbers that you need.
Thank you.
I'm not sure if I interrupted you or not with the line of questioning. I don't know if you wanted to continue with...
Well, I just wanted to make the point that residency restrictions really do little, and we have study after study nationally to show that they're not effective in reducing recidivism. It's these other characteristics of offenders that predict or influence whether or not he's at high or she is at high risk for reoffense. And so what we're doing is we're lumping all sex offenders into one category and saying all of them must live 1,000 feet from everything and not work 1,000 feet from every single place where children might be. When in action, so we're including everyone in that category. At the same time, we all know that there is a significant difference in risk to recidivate against children among that group of all sex offenders. And so we've instituted here in Georgia the Sex Offender Registration Review Board as an entity to use scientific data to distinguish who's level 1, who's level 2, and who's sexually dangerous predators. And so to then have them all have the same consequences anyway just doesn't seem to make fiscal or practical sense, because all of them have to abide by those same restrictions even though they're all different in risk.
Well, let's say we have someone who has not yet been leveled. They're a one-time offender. They come out of the system. Let's say they do a year in jail. They come out. In order to determine that they're a level 1 risk, they have to have been leveled.
Correct.
So in order, I guess the question is, we don't know if they're a level 1 risk until they've been leveled. Once they've been leveled, we do know that, then a restriction, such as it may be, whether under current law or if the law changes, goes into effect. That would seem to me to go to the ability of SORB to level these particular individuals at the tail end of their incarceration.
Which is what we're doing now.
Which is what you're doing now.
Right.
And what is the extent that that's occurring?
You mean how many we're doing and how much?
Right. Generally, how does that, I mean, how is that getting done in the context of the greater load that you have to
Right. We are trying
carry?
to deal with all of those first and foremost. So those that are getting out, we try to level first before we go into the backlog, which is all these other cases that we have. So I can't, Faye would have to speak to the numbers of how many we're getting done and how many because we have to rely on corrections to give us those lists and parole to give us those lists so that we can level them before they get released from prison. Whether we're doing that or not, I can't speak to that. Faye would have to speak to that question.
Because it really goes to all of this goes to the issue of determining whether or not individual X is a level 1 risk or not. And the question is, does that get done in a manner that's timely enough so that upon release they either are subject to restriction X or not? But if they're not getting leveled by their release date, then
we don't know.
Then you don't know.
Right. So that would be something that we would have to look into and see if that's being done, and if we can get that done procedurally with what we have to do.
The other issue with that is all those people that got out before this got instituted, they don't have any way to just ask to be leveled.
Right. And
man on the street that got out 5 years ago that served 1 year in your hypothetical for the minor crime can't petition SORB to say, hey, will you level me?
Right, but I mean, but I think under the provision that we're proposing, or if it's not there now, maybe it could be that they'd have the ability to petition to get leveled,
right,
which would form the basis for them to petition Superior Court to be removed from the registry.
The way I'm reading it, under Section 9 of the bill, let's just say that provision that Representative Abrams proposed, if that were in, and in this hypothetical, still yet I'm going to call him a man, couldn't have petitioned, but in that scenario, the Superior Court judge could ask SORB to level them. But the loop of the man being able to just ask SORB is not.
It would have to come from the Superior Court judge.
Right. Or we could write that in there as an option to capture that group of folks that has not been leveled. Because if we look at the percentages, if 75% of all of those that have not been leveled are going to be level 1, 5% of them are going to be predators, and they've not been leveled at all, or don't have to be leveled because they were exempt because of the dates that the law went into effect. And so they're having to live by the residency restrictions of what they are and the employment restrictions, regardless of what their real risk is. And so that would create a mechanism by which those people who have not been required to be leveled would have to be leveled, and we would capture 75 as level 1, 25% as, or 70 actually, about 70, 20 and 5% would be predators. Because of the people who are not leveled, 5% of them are sexually dangerous predators, and we don't know that, and we don't have monitors on them.
So providing them a mechanism,
right,
I
by
mean,
which to be
ostensibly on
leveled.
paper that they would go ahead and be able to go ahead and get leveled,
right,
in order to appear in front of a Superior Court judge and to petition for removal. As a practical matter, that's not going to happen because of what their level is. They're either level 2 or they're predators.
Right.
The law wouldn't allow that, but it would allow the system to identify them and say, you're a predator. We didn't, you were not otherwise captured in the system. Now you are.
Right, right. And right now we have no mechanism by which to capture all of those folks that were prior to the law.
Okay. Mr. Setzler.
Thank you, Mr. Chairman. Thank you for being here today. Sir, I couldn't be here sooner. Competing imperatives. I don't want to put you in a funny position in answering this question, but could you speak to the my instincts tell me it's inherently an imperfect process. How good are we at leveling people? If someone is a sexual dangerous predator that would, if we had omniscience and could tell thoughts and inclinations, we would, if it's someone we would label a level 3. How good are we at pegging those people and not let them slip through? I mean, I'm certainly sensitive to both false positives and false negatives in that respect.
Sure. We're much better at it than we were 10 years ago and 20 years ago. The science is
being perfected. Of course, there is no perfection in any of prediction or predicting human behavior. We just can't do that. But we are definitely honing in on the variables that increase risk. Study after study after study, nationally, Canada, Georgia, are looking at what those characteristics are, which are stranger victim, young age, criminal history. This is whether or not you've had a sexual offense prior.
Right.
Okay. I'm trying to recreate what some of the other variables on dynamic risk factors are: drug or alcohol addiction, criminality, domestic violence, juvenile history of offending behavior. So, and at the Sex Offender Registration Review Board, we now have investigators that are doing a very thorough job of collecting all kinds of data and information about an offender to then help us score the instruments and use that data to get accurate scores of what kind of risk we're talking about.
Okay. So a lot of it's empirical data based on what's been found from a criminal history or
yes.
Otherwise. Is there a methodology in interviewing these people that certain characteristics can come out? I mean, I don't understand the process.
Sure. Now, the Registration Review Board does not interview anyone.
Okay.
It is strictly an anonymous actuarial based on data exercise. We don't interview people because we do know from the scientific data that interviewing people skews your opinion. They look a certain way, they have characteristics that you find favorable or unfavorable, and then that skews your information. So we do not do any kind of interviewing. We simply collect data that's in the record, that's in the victim report, that's in the criminal report, trial proceedings, DA's report, all of those kinds of things.
It seems, though, that I recall somehow, and I might be misapplying this term or when it's done, from 4 years ago, I think it was when five sessions ago we passed this. There's an evaluation that goes on, a psychosexual evaluation or something like that.
Right.
Is that that's done by a clinician of some kind?
Correct.
Is that part of the equation? Is there a report that comes out of that to your board, or?
If that's been done on an offender, yes, that can come to our board to be used as part of the data, part of the stuff that we use to score things. We don't generally get those because those are usually used for adjudication or pre-sentencing, that kind of thing. If they are part of the record or some of their conclusions are part of the record, then we get those. The offender can use those in appealing a decision.
I guess my question is, that's when I thought about an interview, that's what I was kind of thinking about. Is that something that in itself skews the finding? Is that something that a savvy offender could kind of hoodwink a psychiatrist into, well, and on either side of that, I guess the question is that something we should include? Let's assume for a moment we had the resources to do that. Is that something that should be included?
Well, there are good psychosexual evaluations, and then there are not such good psychosexual evaluations. There is a standard. There is a best practice on what a psychosexual should look like and what it should include. Part of that does include a structured interview process, but then the rest of the data is collected through objective testing, personality testing, and other kinds of testing, so that the conclusions that are drawn in a psychosexual are really not just based on an interview, but based on numerous test battery that's
Do you know
done.
the kinds of tests?
Yes, the MSI, which is the multiphasic sex inventory, would be one.
What is that? If I could,
that is
I'm not trying to badger you. I'm just trying to understand this.
Sure. I appreciate that. The MSI is a 500-plus question test similar to an MMPI, but it's looking at sexual behavior, sexual attitudes, sexual stuff.
Is it the kind of thing that someone can game if they understand what's in?
Good offenders, psychopaths can game many things. Yeah. We also use the Milan Multi-Axel Clinical Inventory, which is another personality test similar to the MMPI. If you're familiar with the MMPI, it's similar. Then we use a whole battery of other kinds of tests, things that are impression management scales, how people present themselves, whether they're working to present themselves in a favorable light. We use alcohol and drug questionnaires, a whole battery. And every clinician has a little different protocol. We also use the plethysmograph that I'm sure you're aware of to collect objective data on arousal patterns.
Okay.
Ms. Cooper.
I just wondered, do we have a number on how many people have been released, how many sexual predators that we have in the state that are out, that have been finished their time? We do.
You mean that the review board has designated as sexually dangerous predators?
No, not since we changed the law, but just how many people do we have? If we went back and changed something and people weren't classified, how many people are out there? What kind of
Well, we're just projecting that based on the percentages that we're getting. So we don't have an actual number on anybody who has not been leveled or has been evaluated by a review board.
Oh, no, that's not what I'm asking. I don't think. I'm asking, what is the population of all categories of sex offenders that are out in the community now, that have already gone through their jail or whatever and been let out on, so
That we know about? Or
that we know about. I mean, that have been through the through jail, through
So
prison.
just the total sex offender population that we know of.
That would be on the registry?
How many?
Not at all.
By this new, since the law changed.
How many total classified of the 15,000?
My guess would be, and I would defer to Ms. Strickland, when the legislation passed in 2006, there were 12,000 people on the registry, and so going up to that 17 amount, I would imagine that.
5,000 of which 100 have been.
Yeah, Faye, do you know how many have been?
How many the board has classified since this section?
Yes, ma'am.
We've done about 1,465 have been classified.
Of which 100 are predators.
Yeah, approximately. Now you have some people that were designated predators by the old board before the new board took place. And then you have some predators that are on the registry that were designated by judges and not by the board.
And all of those would sum together to equal 100 people? Is what you're talking about?
Yeah.
Okay. Okay.
For predators, yes.
I see no further questions. Thank you very much.
Thank you.
Sarah, you're going to have to pronounce your last name for me again.
I'm going to test you on it next time, Mr. Chairman.
I'm going to fail.
Sarah Tatanchi with the Southern Center for Human Rights. I'm really grateful for the depth of the questions that are being asked today, and I really wish that in some ways that we had the opportunity to wrestle with some of these issues in 2006 when this law was passed. I know y'all wrestled with a whole lot, and I really want to commend y'all for what you did with regard to the Romeo and Juliet provision. But the piece of that is left to deal with today is that those exceptions that y'all made on the consensual sex between teenagers are prospective. They apply to people who have been sentenced since that time. Like we were just discussing, there were 12,000 people on the registry in 2006, and 2,000 of those people were in jail. So that leaves 10,000 people who were in the community prior to the new law who have never been leveled by Ms. Strickland's board. We strongly support the Sex Offender Review Board, and but one of the things is that we're very conscious of their extraordinary mandate, the work that they've had to do to level people coming out of prison, and are sensitive to adding more to that. Of course, what would be ideal would be for everybody on the registry to go through the process of being leveled and go through all these extensive tests that Ms. Strickland has explained, and then for their level of restrictions to be doled out based on their likelihood of reoffending. But because this board is something that has come about in a time where our state is very economically challenged, and because they are a small agency that already does extraordinary work, one of the reasons we proposed, we worked with Representative Abrams to propose the amendment earlier, would be a way to get at the same goal of making sure that our registry is really targeting the people who we want to monitor the closest, and allowing the people who may not need to be on the registry or may not need to be subject to some level of the restrictions, whether it's residency or employment, to allow for them to ask a judge to be relieved of that. There's no guarantee that their petition will be granted, but just to have the opportunity to go in front of a judge. And this, again, I just cannot overemphasize that all the people that we talked about in 2006 that fall under the Romeo and Juliet category, the people who are on the registry, are still unable to petition to come off the registry. And that's what we're talking about here. We're talking about those very same people. And particularly now in our economically challenged time, we must be careful that we allow our law enforcement to spend their scarce resources monitoring those that really need to be closely monitored, and not so much the folks who are on there for acts of consensual teenage sex or other minor one-time crimes that have very low risk of reoffending. I would I didn't get to finish telling you all the story earlier of our client who was on the registry for being a party to statutory rape, for allowing her 15-year-old daughter to have her 17-year-old boyfriend stay over. Ultimately, her daughter and her boyfriend were married and had children, and the mother, who was convicted of being a party to statutory rape, the grandmother, never gets to spend time with her grandchildren because she is on the registry. So the implications for these laws go on for many, many years, and with the law in 2006, we cast the net just so wide that we've got to take some time right now and really look and see how we can make the placement on the registry the most meaningful, the most significant, and provide the best sort of mandate to our law enforcement on who they really need to be keeping an eye on to protect public safety, and who might be better off no longer on their already very long to-do list.
And that goes to the issue we talked about earlier regarding who gets to petition
That's right.
off and who doesn't.
Yes.
And that's a dicey exercise in having some conversations, even just in between during the lunch break. Do we do better to perhaps define who cannot petition to come off the registry, as opposed to trying to identify who can?
I think when you said, Mr. Chairman, that this is the issue of where the rubber hits the road on the bill, I mean, that's exactly it. I think there's a number of ways we could go about creating the mechanism that we're talking about here, whether it's
as opposed to this 5-year, 3-year, 4-year, because again, I mean, that gets into the arbitrariness of sentencing,
right?
And as opposed to looking at a particular crime, you know, we have this laundry list of crimes. I'm sorry to interrupt. This laundry list of crimes. We cut it off somewhere, and the question is everything from there down, literally and figuratively. You can petition. Doesn't mean you're going to get off the list or the registry requirements. That's for sure. That's up to sentencing court. And everything from here above, no. So that way we don't get into that, the danger of what's a 5-year sentence here, it's a 3-year sentence here, it's a 6-year sentence here, and that would almost be almost reckless, depending on what you're talking about, because it varies jurisdiction to jurisdiction.
I think you almost have it laid out right in the existing Section 9. It just feels to me that there's criteria that we've been talking about today, that we've come back to numerous times today, that just isn't quite covered here, and I think that's our challenge right now, is to figure out how to get that. If y'all would be more comfortable with a having everybody go through the leveling process and go through the extensive testing that Ms. Strickland was talking about, that could be one option. It would be an option that would cost some money and take some time, because there are always going to be more people coming out for the board to level, and there's a significant, for all the people that were on the registry prior to 2006, about 10,000 people that would have to be dealt with. But that could be one way of doing it. Another way would be to create just some mechanism to allow for people on the registry who have been there since before 2006 to ask to be leveled by the review board. It's just not clear. It's just not laid out.
Or to be able
right
to
now.
petition the Superior Court, who would be able to order the review board
right, and that's
to level them, which
yes.
I think is in the bill. It is. But I don't think I got an answer. And if you don't want to answer, you don't have to. About, do we do better to assign,
yeah.
as opposed to trying to laundry list what is eligible, to perhaps list what's not?
Mr. Chairman, that's a really challenging question for me to answer. Our office has spent extraordinary hours looking at the sex offender registry. And one of the biggest lessons we've learned is that you cannot make a clear judgment just by what's on that page in front of you. So that is where you're hearing my reluctance in assigning just the crime, because it really varies from jurisdiction to jurisdiction what gets charged, what gets prosecuted, and what is ultimately sentenced.
Mrs. Cooper.
I have 2 questions. How many out of that 10,000 do you think would fall into this area where we might be at, where the crimes would fall 5 years or less, or would be of the type of the Romeo and Juliet?
Right. Well, I can only base that on the same information Ms. Strickland was saying, as far as that 75% of the people that they're rating are level 1. I don't know that for a fact, but I do know, I mean, I would trust the review board's analysis.
And how much would there be a way where people could petition, and then how much does a review like this cost if an individual wanted to pay for it themselves, right, to present to the court? Has anybody got an idea how much it would cost?
Well, there's a difference between an evaluation by the board, which isn't an evaluation, it's just an actuarial instrument that we gather the info, versus a psychosexual evaluation. A psychosexual evaluation costs money with a clinician to do that, but that's not necessarily required to be leveled by the board. Does that make sense? So there's two different issues at hand. One is the psychosexual evaluation, one is being leveled by the board. They're separate entities.
Mr. Chairman, good night. Is there somebody else besides y'all that could do the kind of leveling you can do? Since there's such a huge backlog, for y'all, and is there somebody else that could do that and could use the same?
Chairman Cooper, if I could, I think there's something to be said for consistency across the board.
Okay.
And this is the entity that has been charged with carrying out this task. It's an extraordinarily complicated and detailed task, and I personally would feel more comfortable that everybody on the registry be held to the same standard that's doled out by this board.
But as a practical matter, has the board been able to meet its burden, though?
That's it. That's what
That's what we're really talking about, is that has the board been able to actually, and I understand the board is primarily, if not totally, volunteer, correct? So, respecting that, without a mandate, it's not going to happen. And then the funding, then it won't happen. Is that a practically correct thing to say?
And we have gotten, last session, we got new positions approved, and we have evaluators as well as investigators that are really increasing the amount of offenders that can be leveled by the board, because they're working day after day. What's been the rate of increase?
That's exactly what I was going to ask. What's been the rate of increase, the sort of the catch-up factor? And this is not by way, let me just make sure it's clear, this is not by way of some sort of attack of, the work. This is a primarily, if not totally, volunteer board. We're trying to get an idea of, what's been the rate of increase in terms of improvement, and then if we have this bill that's going to go ahead and give the Superior Court judge the ability to order SORB to do X, as a practical matter, is SORB going to physically be able to do it?
It probably would have to have additional staff to do it, of course. But what I want to say is
Can you prioritize? I'm sorry to interrupt, but can you, if you get something from a Superior Court judge that says, do this, my assumption is, as a practical matter, you take that and put that at the top of the pile.
have to prioritize it.
Okay. I'm sorry. Okay.
And if they, whatever time frame they have to do it in, that's what we have to do, but they would have to take priority because it is a temp order. But where there are 15,000 people on the registry now, we have not gotten all 15,000 names. We've gotten a little over 4,500, and we've completed almost 1,500. So we're catching up. We're doing better. We started out with doing 5 cases, then 10 cases, but as the board got better and the evaluators got better, at our last meeting we were able to do 84 cases. So it's increasing.
How many?
84. It sounds to me that y'all have gotten 4,500 names and have made it through about 1,500 of them.
Yeah, but you have the first year we were not working.
Right.
That's only in 2 years.
Okay, those names are the ones in prison now?
Both. They're releases as well as backlog of folks that we've been given to since '06. Since the law went into effect in July
Okay.
of '06. We're not mandated at this point to do all the people before that.
There's just people who didn't release.
Sure. I'll address this to the witness and then generally to those that can speak to it. The thing that came to my mind was the dollars as well. I think if we consider the investment from the state treasury as being somewhat a fixed number that's perhaps downward trending in 11 and 12, I think about the urgency of the emails I've gotten from these people. We've all gotten things from folks in our district or have family members in our district that so and so was a licensed plumber that was electrician making $80,000 a year in his own business. Now he's on this registry and all of a sudden he's lost everything. Economically it would certainly be to the advantage of these individuals to be assessed, even if they were committed crimes against children, to go through the more expensive assessment. So if we were to take, I'll offer this to you, if we were to take, hypothetically, the state investment is fixed, is unchanging. But if we were to say assessment, clinical community, define for us what the process ought to be to work through the existing backlog of people who have not been leveled and give a more substantial review and evaluation to those that we think might be predators, what would you design to include? What would a just like individuals have to pay money to go to a DUI driving school to remedy something they've done there, what would an individual have to lay down for psychosexual evaluation? Is that $5,000? Is it $4,000? You tell me. Is the overall review process, is that a $1,000 investment of money, again, just to fund a system that won't happen overnight, won't happen in 3 or 4 or 5 or 6 months, but over time could be created, maintaining strict controls on quality, to begin to work through this, to give folks their sort of day in court. I mean, if we were to put to you, how would you design it? If you had the ability to set a fee and set all those things in place, what would it look like?
Knowing that SORB cannot physically get through all these situations, if we have the petition for removal becomes law, as a practical matter, if they can't get to it, if I understand the gentleman's question correctly, is if SORB can't do it, and I know it's it's working hard, and we're not here to take issue on that right now, it is what are the alternatives? Is there a private sector alternative that we could even write into the law so that if you're petitioning and you want to go ahead, as opposed to waiting for SORB, if you wanted to go ahead and go into the market and get evaluated to give the Superior Court judge, what does that mechanism look like? Is that what you're asking?
That would be part of it. Or if SORB were the ultimate gatekeeper, how could SORB be grown for a period of time? How could they use outside resources to do a preliminary evaluation, to kind of do the substantive analysis? I mean, if it were turned back on you to say, the legislature is going to invest what it's spending today, that's going to be constant, but you can define exactly what the process would look like to deal with this, and you're given a blank sheet of paper, what would you define?
I don't think you're going to like my answer, but I honestly think that y'all have it right in the bill right now with going through the Superior Court and relying on our judges who sentence people in these cases all the time, who understand deeply the range of kind of crimes.
But the judge is not going to make a move unless they've got something on paper from a subject matter expert like Sorb or whoever saying that this person does not pose a threat to society. And if that person, in other words, it defeats the whole removal process petition for these true non-threats, assuming they are non-threats. If they can't get evaluated in order to present to the judge can make an informed decision. If Sorb can't get to it, what's the mechanism?
Well, I hear what you're saying, but with all due respect, that's the law right now. Is the way we have it set forth is to go through the judge right now. And
but I mean, to your point, and I'll apologize in advance if this is perceived as a crass analogy, but I mean we've had big issues with property taxes in Georgia. So the legislature's looked at ways to have folks get independent evaluations through an independent assessor for your property taxes to take the Board of Equalization to have your, quote, day in court, and it begins to level the playing field. I'm just asking you, and I perceive you to be the chief advocate for these individuals in the state, if hypothetically you're giving a blank sheet to draw a process to represent their interests, it would seem to me there'd be a process that perhaps you being on the spotlight today are not going to come up with on the fly. But I would simply ask the question, is there a way to have some licensed clinician that's got formal responsibilities recognized by the state, not to serve in a role as a magistrate, but to be under the licensure of being a psychiatrist or some licensed somebody to do a preliminary check so that someone can be moved forward in the process in a way they fund themselves. They can't go pick their own doctor perhaps. Maybe they put down a registration fee that then they're assigned someone to evaluate them. You don't pick your own clinician, but some process that can move people through the process so it's not just this gridlock that we see now. Right. Because we, the legislature, and we, the executive branch, has not created the capacity to handle this.
It happens all. I mean, in the state court context, they go assign it to an individual to a DUI school, to a risk reduction. There might be, in a diversion program for on a drug offense, they're going to assign them to X professional. I mean, it comes down to writing into the law the ability for the Superior Court judge, as opposed to just ordering Sorb to do X. Yes, it goes to the top of Sorb's stack. That's fine, but it still doesn't help them get through their backlog. And so there needs to be a statutory mechanism for the judge to be able to say, go through Sorb, or you can go through, XYZ process, on your own dime.
And Mr. Chairman, I'll just close by saying that, and this is just a hearing today. I would maybe broadcast this to everybody in the room that's listening, but I think there's certainly the possibility this year as the legislature contemplates this and contemplates a change. This may be the last substantive change to this that we address. And if this is true, the last bite of the apple on this, I personally, just as an individual member, I can't speak for other members of the committee or the legislature, would ask you to come up with a process you would propose. Maybe you're left out of this committee, but perhaps it's something this committee would consider something consider favorably to get through this backlog. I don't want to solve this and 5 years from now still be tied down by administrative gridlock, that there are people like this mother who allowed her the 17-year-old boyfriend of her 15-year-old daughter to come over, and she's a sex offender. This shocks the senses. Not that she should have done that, but the fact that she can't see her grandkids as a result just shocks the senses. And I don't want to see, in my mind, the advocate community is not doing its job if they can't propose a possible solution to this, at least for us to consider.
Representative Setzler, we did offer some language this morning, and that's sort of what we're wrestling with right now, is that perhaps the committee wasn't as happy with the language as I might have hoped. But I'm more than happy to work with the Sex Offender Review Board in coming up with something. I will just put out there as a word of caution that when we're talking about something as, I mean, I understand that drunk driving is a very serious issue, but sexual offenses seem more severe to me. And I would just think that the state would want to have as much jurisdiction over the entities we're trusting to make these very important decisions about an individual's likelihood of reoffending. I would want the state to have a lot of oversight in that. And I can tell you right now that the range in which sex offender treatment is being provided throughout our state it's huge. There are some solid, wonderful programs that I strongly support, and then there are some that are folks that hung out a shingle and are getting referrals from the court. And that's sort of where my caution is coming from.
Well, there would be. I mean, there would obviously be oversight. You get, our our agencies put out approved lists of, of approved vendors or approved, mechanisms depending on the issue. And we understand that it's not equated to a DUI, but there still are mechanisms throughout our law whereby you can go and get some sort of service in the private sector, bring it to an agency and say, see, here, I did this, whatever it may be, and assuming it's an approved, I don't know if it's a vendor or an approved provider, whatever it may be, then it carries a lot of weight. But there is oversight that has to come with it.
Right.
I'm saying that understand that what Mr. Setzler is saying, it goes to the issue of we can have all these mechanisms for petitioning all you want, but if there's a backlog, it's useless. So what he's trying to do, and I agree with him, is to set out a mechanism. Well, if SORB can do it, great. But as a practical matter, are they increasing their rate, their rate of completion on files? We assume so. Is it going to get to the point where they're going to catch up, and be caught up anytime soon? No. So in the interim, for the people who I assume you're advocating for, we're looking for a mechanism that, if these are people that are worthy to petition off, and we have not determined that yet, but if we do get to that point, the question is, what is the most streamlined manner to do it that makes sense? I think what he's proposing is right on target, provided there are certain safeguards that are put in there, because we are talking about a very serious subject matter. This is not a drug diversion. This is not a DUI defensive driving school. This is a psychosexual evaluation on a potential predator in our community. We get that. We get it. By the same token, we have to make this law work, because right now it's not. So understand that we're trying to strike that balance.
I understand.
Okay. Mrs. Cooper.
Okay. This is for the board. If I heard you right, it sounds like to me that right now you could write guidelines for each of the categories. Am I right? That would be guidelines that a judge could follow for the basic indicators for levels.
A judge could determine that.
What?
I mean, you're asking whether they could put forward guidelines that a judge could use in order to go ahead and determine the level of risk himself or herself?
Or not necessarily, but to decide whether if this appeal should go forward or not, would at least give them a guideline of knowing how they would have been. I mean, if I was a judge and we can't go back in the backlog, and I've got this person before me that has petitioned, and I had guidelines that I could pick on a piece of paper, then I could look through and see there was no history as a child of problems.
Mm-hmm.
There were no other crimes committed. There was only one-time offense. The things that they said under level 1, then I would have a pretty good feeling that this was a level 1 offender, and then I could go ahead and answer that.
Sure, but you've got to get that.
Well, that's what I was asking, if they could do that, if somehow we could incorporate it, and then perhaps give the judges the alternative if they don't, to send somebody for evaluation if they needed to.
Mr. Chairman, I'm Angie Holt. I'm the chair of the Sexual Offender Registry.
Sit down if you like.
Part of the problem with the backlog for the Sex Offender Registry Review Board is getting exactly the information that you're talking about to provide to the Superior Court judge. If we had that information readily available at our fingertips without our investigators having to spend a lot of time getting that, then our evaluators could complete more cases and in turn turn more cases over to the Sex Offender Registry Review Board. The board itself takes information that the investigators compile from the district attorneys, from the Department of Corrections, and from other places, local departments and things like that. Then the evaluators take that and assign values to them on the rating instruments that we use, as Dr. Strickland talked about with the Static 99, Static 2003, and the MinSauce. But to provide the Superior Court judge with that kind of information, or for them to get that information, would be an arduous process.
I mean, I understand that you're collecting all that information on individuals, but are you telling me there are no national guidelines? There's no national information from studies and things that have been done that don't indicate general guidelines?
If you're talking about general parameters.
That's what I'm talking about. For a judge on these backlog of cases.
Certainly what we do is we use the instruments that we have, and I'll be glad to send you a copy of one of those, but that it takes into the consideration the same things that Dr. Strickland said. The level of violence used, the age of the offender at release, the number of violations, the types of violations there are, whether it was in a public place or not, how old was the offender, what was the gender of the offender, and there are numerous categories. But in order to get that kind of information is what I'm talking about, that gathering the information to stick them into those categories is a long process.
But you're saying that, and that's not available in the person's chart or whatever they go when they go before the judge? Their record, it's not a part of it?
Could you move the microphone?
I know that, but if they were allowed to go before the judge, are those things not in there when they were sentenced and so forth? You know, the prosecutors didn't come up and say this person or.
Well, it may or may not be.
Right.
You know, especially with past history.
Okay. She's.
May I speak?
Sure.
There is one of the things that's done is a pre-sentence evaluation, and yes, much of that information is in there. Not all offenders are required to have a pre-sentence evaluation that would do a risk assessment pre-sentence. So I think one of the things you're talking about is a post-sentence evaluation, and that if offenders were if they wanted to appeal to the court to get off the registry, then a post-sentence or another psychosexual evaluation that used these instruments that the board uses would be in order. It's just a matter of how you get the offender, get that information to the court, whether that comes from a clinician who's qualified to do those instruments or whether it comes from the review board to the court.
Mr. Chairman.
Sure.
Okay. We're looking at numbers, 10,000. And if you're saying 75% of those might fall into level 1 and in theory might ask to have a hearing, that's huge numbers. Okay. Is that if they had a pre-sentencing evaluation, would that be good enough for them to move forward to the judge in that, and without having to have a post-sentencing or not?
That doesn't necessarily reflect the risk that they will be at release, though, because that's a totally different time. Then they could have problems in incarceration that will completely skew their results. Is that a correct statement?
Correct. Okay. Absolutely. So
okay.
If they had a pre-sentence and served 10 years in prison, that pre-sentence is no longer useful in predicting risk at release.
Okay.
They still need an evaluation at release to predict risk.
Which is why, and this goes right back to Mr. Setzler's point of, in an ideal world, regardless, let's say we didn't have this potential petition for removal. Right now, SORB, has a backlog. And again, not getting into the weeds on that, but as a practical matter, if they can't handle, if they're behind now, if we have this petition situation, potentially, it's obviously not going to help their, relieve their backlog. And so what is the alternative? Is there an alternative? Should there be a statutory mechanism? Again, if this registration removal piece is put in, is passed and is signed by the governor, as a practical matter, you're going to have some sort of alternative for the Superior Court judge to say, I'm going to order, an evaluation, a psychosexual evaluation. There should be, and there could be and should be parameters for that, whether it's a particular provider, maybe it's a particular provider approved by SORB as per their rule and regulation authority. Whatever the mechanism is, it's been done before. That's what it really comes down to. Now, are you going to necessarily have the uniformity of SORB making all those determinations? No, you're not. As a practical matter, no, you would not. But the Superior Court judge will have that file in his or her hand, knowing that it comes from a credible provider as approved by SORB in their regulations. He or she takes a look at it and makes their best judgment possible, because that's what they do. That's their job. That's what they get paid for. So as a practical matter, I mean, you can talk about this removal all we want, but if there's no mechanism for the evaluation, it's a waste of time. It really is. So I think we're going to have to, if we do end up doing that, we're going to have to, I think, as a practical matter, put that in there as a mechanism for the evaluation, for the leveling, so the judge can take a look at it and make a cogent decision. Yeah.
And Mr. Chairman, it may not be the definitive leveling. It may be a findings, clinical findings. I don't know what it looks like, and I still think there does need to be a government entity that's the gatekeeper of this. I just somehow it would seem there'd be the possibility of people who are motivated themselves to get off this, to put some money on the table, to fund whatever needs to be funded. To the extent there's a bottleneck at the review process and the board level, then I don't think anyone on this panel is going to disagree with that. I just think I think it's a given. There are budget constraints, but in this kind of thing, to the extent money is the problem, that I think can be brought to bear by families and by individuals. To the extent there's an inherent control that needs to be in place, then it's our job to maintain that valve of how tight that needs to be. I think it's our job, and I don't think anyone in this committee is going to dispute that. I just would like to hypothetically take, or I guess in theory, take the money piece off the table. That could perhaps be funded somehow by fees and by some other stream provided by the individual. I guess that's all I've proposed at this point.
Yeah, and I think it's a good suggestion. I mean, as a practical matter, it's going to come from the individual. I mean, it just is in that situation. What you talk about really goes to the integrity of the provider making the evaluation. That goes to, again, the oversight by the governmental, quasi-governmental body of, that's got jurisdiction over it. And that's got to be a rigorous process. There's got to be rigor that's involved with it. But to this minute, I don't see an alternative to that, provided that the integrity is kept in place.
And I would say, even from the standpoint of, liability, I don't think that maybe I'm jumping 2 or 3 steps too far ahead. I don't think that the entity that makes the evaluation should have blanket waivers of liability. I mean, I think there needs to be some from a tort perspective, some skin in the game from their perspective, that they follow a standard of care and they do an evaluation that has the integrity and the same standards that would otherwise be maintained. My fear is that this becomes a cottage industry, and processing these things through for certain clinicians becomes kind of this something that becomes more of a volume business for them. That scares me. I mean, I'll put that on the table. That certainly concerns me. But I think if we're able to manage the risk piece and the tort piece just right, that there was an appropriate fear and respect of the process, that the clinicians not be enticed into a sort of a volume business to process these things through quickly by getting in the business of processing these evaluations, but there would be this appropriate respect. I think we could manage that somehow. I just think it's a careful balance.
It is, and I think the liability piece, I don't see how it's any different than any other. I mean, my sense off the top of my head is that the liability piece would be handled just like it is now in any other context. Yes, ma'am?
We keep talking about the person paying for this. I sort of get the idea that many of these people are indigent because we've made it so hard for them to work, or they have trouble getting jobs. Is that
there's a significant portion of people on the registry who are indigent. I don't have an exact number, but there are a lot of folks who are on there that do have more family resources than quite frankly many others do in the criminal justice system.
There are. Well, right. I just saw somewhere where they wanted to reduce a 250 registration fee each year because they can't afford it down to something like $65 or something. So I wondered if that would be a major.
I think some people will be able to pay for it, but by no means the majority of people on the registry.
But if you can alleviate the backload by those who not only can but are desperate for the opportunity to do that, I think that ends up being a non-issue. And again, it just gets them in front of the Superior Court, and the judge can say yes, no, or come back in X amount of time. So, and it's, we're not trying to be argumentative. In an ideal world, it would be SORB that would, end up doing it. But as a practical matter, I don't see it. And it's not a criticism of SORB. It's not a criticism of SORB. It's just an acknowledgement of the reality that we're in, and a further acknowledgement of the budget situation that we're in. And and as we recover slowly, more resources will go there. But in the interim, the whole idea of this is that this portion of it is the potential for individuals who perhaps, the key word being perhaps, shouldn't be on this registry. The mechanism for them to petition off, it's all timing. It's just a timing issue. And I think what Mr. Setzler said is right, but the rigor and the integrity of that process, the credibility of provider A, B, and C in doing those evaluations is paramount. So we'll get to it. Did you have anything else, Sarah?
I just want to thank you, Mr. Chairman. I know you've put a whole lot of time into this bill, and I'm grateful. I want to recognize our opposing counsel and the Attorney General's office for their incredible work on this bill.
It's very gracious of you.
Thank you.
Very gracious. Right, the Attorney General's office declines your gratitude. We'll, this is to be continued. We'll take the testimony and the suggestions, specific suggestions that we've had today, and try to incorporate that into another sub. And we'll, I don't know if we'll do this all over again, but we'll certainly go ahead and circulate a refined sub to the committee members, certainly, and to interested parties, sooner rather than later. And we're adjourned. Thank you.